Yes.
Counter has been filed to the review application, the region that I did it, I am highly secret, and I am serving the copy of the article.
Madam, you have been persistently mentioning the matter to be taken up out of time. I always believe, because I was there for a 19 and a half years there, that whenever any pleadings are filed, it should be given in advance to the other side so that at least they can come ready. If you give it on at the time of hearing, they will definitely ask for an adjournment that I have to go through those. You are delaying the matter.
I agree to lot.
So,
But I am not out of court because it was directed to be listed.
why you did not serve? Why you did not serve is in advance. That is my request to you with a folded hand, that why you did not when you had that.
Kindly see order dated 28/10/25. My lord sir specifically directed counter to be filed within 2 weeks, rejoinder.
Whatever, it may be a delayed one, there is no difficulty, madam.
There are 3 days holidays below.
I am arguing. Because false statements have been given by them, and this review application, it is a mistake committed by the court which can be only corrected. There is nothing, and read application was filed against the bar council, state bar council, and the election official to delete the name of the present petitioner. And they have filed in favor counter affidavit stating that no, they have the read petitioner has suppressed materials and false allegations have been made by them. Rather, criminal prosecution should be made against the advocate who has, and now also they have.
Madam, can you prevent any litigant to take a plea? He can't take a plea. It is only when whether the court will accept such plea or may not accept such plea. But you can't prevent anybody from taking a plea.
It's my case is that when against the violating the rules they have filed, that president has filed, he is not, he cannot file the case because the rule provides that only joint secretary or secretary can file the case. The president has filed the case of only the lady advocate to take
application. Thrice matter like mistake.
only to restrict a lady advocate when there is an nara that lady advocate they should come.
The difficulty is that, madam,
State
please pardon my impertinence in this.
This is denied. Now the ensuing action will be.
Pardon my impertinence. You have come before the court of law. Before the court, it is immaterial that who is there. What is material before the court is the matter. We should talk law.
Yes, only
Whether the law, the personal inhibitions, the personal reservations, the personal emotional things, these are all kept aside.
Yes.
Come on the proposition of law. You have come in a review.
Yes, ma'am.
True. Now you should know the scope of a review.
Yes.
True. Argue on a scope of a review.
Yes, ma'am.
Tell us that what is that. If we find,
yes,
as you said, there is a mistake.
yes.
Definitely, I am conscious. Actus curi naninam grababit. That principles is known to me. No problem. You just concentrate on the proposition of law.
Yes.
Please.
That order, my lord.
You are seeking review of the order dated 30th of April.
Yes.
Just give us 15 seconds time to go through this. Yes,
my lord.
madam, but just 30 seconds time to go through this.
Okay.
Let me hear. Lord. Sir, there is one thing which is really galore on the record. The order number 6 was sought to be challenged.
Yes.
So once we took up that particular appeal, we only concentrated on the first part of the order. I think the second part of an order was overlooked in that regard, and by virtue of which certain right has been impeded. Now, in that event, it's an error apparent on the face of the record. What more one can add?
My lord, one submission, my lord. My lord, that order has been given effect to long back.
Maybe, sir,
And
but
once
once the review is sought
Yes, ma'am.
and it is he is seeking refund. Why you are not taking a decision? Communicate either yes or no.
The decision is already taken.
Take it. Here. Refund? No refund. You are happy?
But not in.
Uh, the instant petition. Yes.
But it might be bulkable because of the contract documents that have come, otherwise the issue is very limited. I will take your logbook straight away to page 697. That is the next.
Why don't you segregate it in two parts, two volumes?
But actually, that is not being accepted by the registry because they have tried in one of the matters, they said no.
Why they will not accept? I will pass an instruction in
Because
this
the
regard.
spiral binding to
Because
make it
Not spiral, it has to be, now,
The
it should not
contract-
contain more than 250 pages.
Yes.
It should not. Yes, what is the page number?
697 and Annexure 27. So the earlier order on my approach, which was the inner order which was passed by the earlier lord, the acting chief justice,
Without-
and Justice Raman, for the
Without
disposal of the
expressing any opinion.
Yes.
What?
And
To consider.
consider my representation, which is at Annexure 26. So while considering that, what they have done is after rejecting my representation without getting into any of the issues that I have raised, they issued an order of blacklisting along with that. That is, my lord, at page 704.
704 or 699?
No, my lord, 704. There is a rejection at 699.
Why to say the 18
No, that is the rejection of my prayer for forfeiture regarding the forfeiture, which was rejected at 699. And
What
In
order you
addition-
have challenged?
Lord, I have a challenge both, but I'll just say
Should be
take
careful.
to that. Lord, while rejecting it, though they have not considered the objection, but in addition to that, after that they blacklisted.
It's allowed many orders.
Huh?
Annexes 7, 8, 10, 14, 15, 19, 21, 22, 23, and 8. That is why that they have, I think, the registry got confused.
So this blacklist.
I think you have not left any stone unturned. I
No,
think
the
whatever,
reason is
even if they have directed the service of notice, you have also challenged.
No, my lord.
What kind of a drafting is there? Whose office?
That's mine.
What are you doing?
Why it is been
Annexes
challenged?
4 is
The orders also on the same ground. We
So
have forfeited.
you have to challenge the current
consequence
order.
of-
These are, if you have not challenged the main order, consequential orders are dependent upon that.
Annexure 4 also you have- Annexure 4 also-
Because I want your office to go to all.
Annexure 4 is bank guarantee. That is also
That is
That is
also
also
challenged. My goodness.
Because bank guarantee have issued for disqualification, they have prepared to refund that.
Mr. Siddharth,
Everything is challenged. What is this? Do you not apply?
Bank guarantee.
Will you not apply your mind?
I'm sorry. This was because this consequential orders are.
No consequential order. Where is the order of debarment?
That is 704 if your lordship should see. 29,824. They blacklisted. Against that, again I gave a representation. They considered it and lifted the blacklisting. But so far as the forfeiture is concerned, again they ignored everything.
No.
So the
Where is the order? Where is the order?
Record order is at page 712,
parties.
Annexure 31.
Parties. So 29 is not challenged.
Oh, I could not get it.
Annexure 29 is not sought to be pushed.
Withdrawn. The blacklisting was
So
withdrawn.
why you are drawing our attention to this? Where is the order withdrawing?
Yes, madam. That is 712, Annexure 31. That was revoked. But the issue regarding so far as the forfeiture is concerned, in neither of the order, they have taken up a single issue and.
Where is the order of forfeiture?
Yes. That is annexure number 23 and page 6AA.
Yes.
This is the letter issued to the bank for forfeiture of bank guarantee.
No, that's the invocation of the bank guarantee.
Yeah. So, my lord, against that I made the representation. I came up before Lordship. Your Lordship said to consider that and dispose of. But the grounds that were raised by me in my representation, none was addressed. Then, along with that, while rejecting that representation, they added the blacklisting.
Now blacklisting has
And
gone.
withdrawn.
So-
But till date, my reasoning given for the non-justification of the forfeiture has not been considered by them. That is my limited prayer if they can reconsider to that extent. Because the grounds that I have taken absolutely.
Where is the ground?
Yes, if your Lordship would see that order at
No, where is you have raised a ground where?
annexure 26, if your Lordship would see.
Page, I do not have this.
693, I'm sorry.
Yes. Because I'm looking at the hard copy, so I do not know.
I'm sorry. Your Lordship, so just one paragraph I will highlight. At page
Yes.
Yes, sir.
This the only reason is that there was a paddy land, nothing more than that.
Nothing.
Then that invocation is justified.
No, my lord. The land was never, the site was never handed over to us. If your Lordship, that's why I said I'll just draw your kind attention, your Lordships to page 7.
Did you brought it to the notice?
Yes.
So person.
In our so-cause, we gave it. And even the subsequent contractor could complete in 1 year only 5% because of the very same reason. So to reconsider my.
This 29/12/23,
Yes, ma'am.
this page 693,
Yes, ma'am.
that is the reply.
That is one, and the similar reply is also at when they blacklisted me, I have given also.
This you have given in relation to blacklisting.
No,
34.
Ashok of blacklist.
Appendix
Yes,
34.
Yes, ma'am.
Your subject is appendix 34, that is
Yes.
blacklisting. So with regard to bank guarantee, nothing.
That is at annexure 19, ma'am. That is page 679.
679.
679.
So from issue.
No, that was
Because then
the issue. Where is your reply?
annexure 20, 682.
No. It was related to something else for submission of the performance security.
Security.
So you are challenging this also.
They are challenged because there is a clause in the contract. If your lordship should come to that clause.
Sir, when you enter into a contract, did you enter with a closed eyes?
That get to the disputed issue.
So-
I don't want to get into it.
You can't.
No, my lord.
What is-
After that, if your lordship should see the forfeiture order is annexure 23, where they invoke the bank guarantee.
Yes.
Against that also we made a representation, my lord, which is at annex 20. Lord, just before that, annexure 21.
So they wanted you to deposit the performance security within the extended time. You did not deposit. They invoked that particular
No, my lord, I
the
just-
provision of the agreement,
No, why?
and then
the
forfeited.
Performance security is attached to a base price given by them. The
Whatever be the reason,
So,
but there
I'm
was
not that is why, my lord, I
So-
said I'm not getting into it because that will be the
No.
factual issues. So, insofar as the consideration is concerned, nothing has been taken in that. So that is why I said if they can reconsider.
So this is what reconsider. That was in 2021. They have already invoked the bank guarantee.
Till 24, the issue was going on, and I.
So whatever they have invoked way back in 2021, what you have said regarding this in reply to this letter?
I'll just, my lord.
Where is your reply to this letter?
That is, my lord.
No, against this letter, when they intimated you that we have invoked
I
the
hope-
clause this.
I hope that is annexure 18, which is reflected in
In the earlier
order.
23.
Where is that? What is that annexure?
That is,
We have-
my lord, that is that annexure, my lord, that is 26.
So what is that
No,
annexure 18?
26.
Annexure
26, 20, that is 29/12/2023,
693. Page
693 page.
That is regarding blacklisting only.
That is a blacklisting one.
Feature, my lord.
So they have considered and they have withdrawn.
No, blacklisting they have withdrawn, but the forfeiture is.
But where was the issue relating to this letter of 21st December 2021? Where is your response to a letter of 21st December 2021? Tell us.
As per our order, they have considered this and withdrawn.
Or at best, the letter which was written subsequently.
The time is 25. Its first time is 25 is 26.
You also again
Because that
blacklisting.
Lord, this letter was 29/12, was in response to the annexure at 25, page 692. But insofar as that is concerned,
Can't be.
because that is only regarding the performance bank guarantee.
So,
But in the subsequent at annexure 30, well, giving against the blacklisting,
no, that is again, please forget about a blacklisting. Now that issue is over.
blacklisting
They
is
have already withdrawn. So you cannot be said to be an aggrieved person.
right.
So far as the invocation of the bank guarantee is concerned, it was as far back as on 21st of December. And you did not raise any objection that it does not warrant any invocation of a bank guarantee. Where is your response to this letter of 21st December? We will direct him to consider, provided there is a material before him to raise. You cannot get a fresh lease of life.
Lord, also should
Show us
annexure 20, that is 25/11/2021,
25,
page 682. Page 682,
25.
25/11/21.
So invocation was in December.
Yes.
After that,
Considering this.
I am asking that this invocation they have done, you have raised an issue that you could not have. I'm just trying to ponder upon this issue.
Sure. In reply, they did not consider and
After that, have we given any?
I just wanted to know that they said that as per this clause of the agreement, they are going to invoke. Have you raised an objection that it cannot be invoked?
The lordship should see. I'm sorry, my lord, as your lordship stated, but only there is a challenge to the quantum. That is at annexure
No,
690.
no, that
but
cannot,
not
cannot be done. If you have not raised, then how can you come? How can we direct the authority to take a consideration? You have to raise.
But so far as the bid security is concerned, we had raised objection at annexure.
That is a different issue, Sam, again. Invocation of a bank guarantee, I am just concerned about. If you have raised an objection, they have not considered it, they are at fault. If you did not, how can we brand them that they are at the wrong footing?
ensure so.
No.
It's going to be here, so called, then they invoke. After that, have we given?
I'm confused.
There is.
Our order. There's no.
Prior to that, they had given, but after that. they have-
So how can it be?
You challenge that.
You did not challenge this order.
Yes, we
We have.
We have.
Earlier it put.
In other it's not challenge.
And there is no reference.
Challenge.
Then what was the representation?
But representation was so far as.
Only the department.
Annexure 18 only.
So you challenge, then I am taking that plea of the law. If you have claimed a multiple release, if the court has granted only one relief, even if there is no reference, it is an implied rejection. Borrowing that principle's explanation 4 or 5 of the section 11
11
of the CPC.
constructive resident.
No. Is what constructive is another one. It is different.
But I rest my case subject.
Yeah, to be very, very
Yes.
pertinent
So far as the
about it.
documentation is concerned.
Have to be. What they will consider? Can we say that they are at fault? If you have not raised any issue, the issue was not there. They are not supposed to decide that issue.
But though they have stated in that rejection order regarding the forfeiture also.
That is a different reference. But that does not mean.
Though the decision was taken earlier, so far as the forfeiture is concerned.
And you have not raised any objection. What your junior is saying.
You say we have raised the objection.
Where is? Show him that he is so pertinent. After 21st of December 2021, show us that you have raised an objection.
21st December 2020.
Just show us one letter that you have raised an objection to forfeiture that you cannot invoke this clause of the agreement. Cannot. Sorry, we can't. Yes. Will you write or should I write? Small. Huh?
See, only one I just put in one document, 70 days. 710.
That's from the above. It is also.
Just, this is, just let us see from which
This is after the Lord
the order is passed.
blacklisting.
And my fourth picture has also been here often.
Would be all.
See.
Clause 12, no. No. No, sir. It was in relation to a debarment.
That was just at page 7.
There is a reference of a forfeiture that does not mean that you have raised a ground. That was in relation to a blacklisting. Mere reference of a fact and challenging a particular incident is two different concepts.
A sailing has to be on its own.
Absolutely, on his independent footing.
One reason cannot be imported into the other one.
That is what.
Public.
Should I dictate? Yeah? Small one. The challenge is made to
will be the big document on which LOA.
That's a concluded contract.
No, they, in their.
It is,
document
it's,
itself say-
then we will say that's a misnomer.
No,
They say that,
Once we-
that the tender documents is there and then there will be a contract executed. Tender document, the terms and condition itself constitute a contract. If
they say LOA.
parties, yes, if the parties accepted and participated, offer and the acceptance is the
That is.
fundamental. So we have, there are issues, there are a decision on a contract act. There is a difference between a contract and a concluded contract.
Item number 4.
So there are two items, Lordship. As sole grievance, Lordship, the state government has come up with the both original code and subsequent guidelines. How the tender can be floated, Lordship, they have adopted the e-procurement since 2009, Lordship. And they have adopted the modalities, how the tenders will be completed and how that will be invited. And Lordship, can you see the glaring example in this case, Lordship? The state government initially has come up with 20 lakh, then it reduced to 15 lakhs. Now this 2 lakhs, Lordship, e-procurement has to be done. But in this matter, Lordship, the tender invited authority, without adopting, Lordship, e-procurement on its own, Lordship, he is, by adopting the traditional method, has awarded the tender to his own near and dear, without giving participation to the Lordship, intending bidders.
Serious allegation.
Let me complete.
No, that is a complete one.
Lordship,
If he says that it is a e-procurement is the order up to 2 lakhs
up to 2 lakhs, that there no notification, Lordship.
or upon after 2 lakhs
More
or
than 2 lakhs.
more than 2 lakhs.
2 lakhs, Lordship.
So if the value is more than 2 lakhs, then how can you do it?
Millet, my humble submission is that Millet. Actually, it is drawn to e-procurement. Millet.
It is.
Yes.
So
Don't have any
then
case.
they don't have any case.
Any case, Lordship.
Then they don't have any case.
Any case, Lordship.
Millet, their case is that Millet. One provision of OPW court is not followed.
Oh, that is what his argument is that e-procurement is the rule. It is a law. If you do not follow, then everything has to go.
Lordship.
It is
And if it is done, show us.
and it was published widely in the newspaper. Millet. The
No, the e-procurement, is it any restrictions imposed in the statutory document that is where those tender has to be uploaded only in the newspaper, or there is a website which is also dedicated for that? I'm talking about jail.
Millet, actually, Millet, in this case, there is no restriction for that. Millet. That's fine.
No, I do not understand. Restrictions and no restrictions. Can you give a short affidavit in this regard? By this week?
By Lordship, can you fetch notice only one paragraph sufficed? But that's saying, Lordship.
No, it is there.
Let them file a.
That for wide publicity, the said tender and corrigendum has been duly published in 3 reputed newspapers.
No,
One is around Odisha, the Samaj, and from our.
That is not costly matter, Lordship. E-procurement.
E-procurement
speaks of section
policy
40.
is something different.
Lordship.
You have to say that they have one guidelines regarding e-procurement.
E-procurement, Lordship. I have to register,
So-
and I will apply on online.
If-
Lordship
if it
should make
is
it
more than-
transparency. So Lordship, they have made it in a traditional manner. They drop it in a drop box.
Maybe-
They will send with the
maybe-
letter.
No, that is not a e-tender then.
No, Lordship.
It's not a e-tender.
Lordship,
Maybe
can you see that
e-procurement.
only?
So e-procurement is something different than
definitely.
e-tender.
Lordship.
That is what he is flagging it.
That's in see paragraph 2 of my instruction. Millet.
Yes,
Paragraph 2 of my instruction.
there is no, where is a paragraph? I do not
Millet,
find.
paragraph is not numbered, Millet. The first.
That for widely publicity.
Last line, that's it.
Yes. That the tender along with the corrigendum has been floated online
Yes,
in 2 numbers of departmental website. It's correct.
This
Then
is
how the
online
tenders were invited, online or by dropping of the box? That is what is
Lordship,
said.
Page 61 class 3, Lordship. Page 61.
online.
Class 3 is very, page 61, Lordship, can you see? Page 61, class 3. The original developer should be only received for extra post
Page,
for page 61, Lordship, the
Yes.
bill, Lordship. Only clause 3 lordship suffice, other conditions are there. Clause 3. The original B document should only be received through registered post, speedy post, person, on or before ethics and other means of posting are not allowed. So lordship, it is never e-procurement. So that is the entire game they have played, lordship. And then to that all they're saying everything lordship, that is a drop box, that is
So where is the rule?
rules lordship. I have annex lordship page, annex of 1 lordship. Annex of 2 series.
That is the OPWD code.
Yes.
Yes, definitely. Are you not bound by that?
Milord, let them complete, Milord, I will go some.
What?
Milord, actually it comes under the OGFR, Milord. The rule is different.
Oh. What is this OGFR?
That's it.
It's a good question.
Guidelines have the OPWD code.
That requires e-procurement portal of the government of Odisha.
Lordship.
So they have not published there.
Not published lordship. And lordship in their own.
No. This is Odisha General Financial Rules.
In their own advertising.
Just.
OGFR rule.
One.
It's a rule number different.
So what do you want to derive?
Milord, we have uploaded in our department.
No, he's not saying that the uploading is an issue. He says you may upload it. But if there are guidelines which is issued, which says that how the participation and the procedures have to be followed. The procedure has not been provided in Rule 216. It simply says that how you make a publication. But thereafter, how it is to be done, the procedure will come here.
Milord, now the procedure is, Milord, page 21, annex 2.
True,
Milord, clause number 6, Milord.
correct?
The government, after careful consideration, has decided to host all tenders costing 2 lakhs or above in the e-procurement portal.
True.
This will be applicable across all engineering departments such as Work Department, Department of Water Resources, Rural Development and Housing Urban Development,
True.
Government of Orissa. Also welcomes hosting of tenders by any other department,
Yes.
authority, corporations.
So
local
it's a wide one.
Yes.
So it is applicable.
But this forest department is concerned, Milord. They are uploading in their own website, Milord.
No, this is on their own website. There is no difficulty. E-procurement portal, it does not say that of a particular designated garment. E-procurement portal may be of a different departments. Not centralizing. And it is also covered in other departments as well. Forest department is outside the department of a government of Odisha. What is the meaning of all other departments? Means those who have not been mentioned here.
Yes, Milord.
So-
Milord,
If it is a central government, that's a different. If it is coming under the state forest department, then
so far, my allegation is concerned that it is done manually, Milord. Let's see, kindly see that advertisement I have annexed to that instruction, Milord. They have already written that it is floated on the website and they can access the website and submit that, Milord. To that effect, I will file an affidavit, Milord.
they can access. Have they submitted online? Or they have sent it by post?
Milord, 5 persons, it is 4 persons they have submitted. The present petitioner never applied for that, Milord. Now thereafter, when everything is concluded, Milord, work order is issued. Now he is challenging that it was not widely published and it was done manually, Milord. Now I need to file an affidavit to that.
File affidavit. Affidavit by 2 weeks, reply by 1 week, matter to appear after 3 weeks.
Item number 5.
I'm appearing on the behalf of petitioner for serial number 5.
Yes.
My impending order is 6 Pasai without jurisdiction. The NHI has travelled beyond the four corners of the tender agreement by not only the blacklisting the petitioner, but also forfeited the amount of 31 lakh rupees, which is not in the clause of the tender, my lord.
You have said only challenging the forfeiture ground.
Yeah, my lord.
You have not challenged the debarment of blacklisting.
No, man, I'm not challenging the department blacklisting because it was under the clause of the agreement, but forfeited was never a part of the agreement, my lord.
Yes.
And Exhibit 7, page 149
Yes.
is the impending order by which they have.
File count on
What count?
on behalf of OP number 18.
Who has forfeited? OP number 2?
Yes,
My lord.
You are for OP number 2?
OP number 3.
Oh, he has challenged the action of the OP number 2. Are you representing OP number 2?
I'm representing OP number 2.
So I am concerned with OP number 2.
Whom are you appearing, sir? National Highways Authority.
Yes.
So OP number 2 and 3, both you are appearing.
Yes.
Say that. So you appear for 2 and 3 both. You are for the Union of India. Let them file an affidavit.
My lord.
2 weeks, 1 week, 3 weeks.
Here, Malab, here, representation of the part number 2, and that representation is filed on 23/9/2025. That's not been disposed of. That is pending consideration. So during pendency of this representation, right now this application is filed.
He wants to file counter.
No. You want a representation?
My lord, I want a counter affidavit better to decide before here, my lord.
What?
My lord, I don't mind for the counter affidavit as well, my lord. Even they will cancel my
He wants
registration.
counter affidavit.
Sir, you want your representation to be considered?
Yes, my lord. During the pendency of the
So let them
petition.
consider.
My lord.
Give that. Yes. Take a decision within 3 weeks.
Already been rejected.
It is a rejected one.
No, ma'am.
You have not taken any decision. You have simply forfeited the security deposit. So they have raised an objection that you can't forfeit. Have you taken a reason? Have you assigned a reason of justifying?
That is where Annex 7 is there.
What?
That groundswell he has taken, that is in Annex 7.
Correct. Have you taken a decision on that?
No, ma'am, the representation is pending.
So consider the representation. Yes, next.
Annexure 8. Annexure 8.
My lord, one more request, my lord. My lord, they kindly direct to consider my representation in the light of the clause. Kindly direct to consider my representation in the light of the clause, my lord, of the
That
agreement.
we can't. You can't dictate the authorities how to do it. You go before them. You will get an opportunity. You go and apprise them everything.
My lord,
We will not say anything.
Item 7.
I am deeply obliged.
Afford an opportunity.
We discussed final amendment. I number 27/26. I filed an amendment.
Flat,
26/26.
flat.
It will not be there. It does not reflect on the cost list. It may not be there in lordship read.
Why?
It does not say so.
When you find?
I don't know. Fourth January.
Why it is not reflected?
Not there in the cost list, but it may be there in the.
No. I'm just talking about what is the number?
Number 27/26. I number 27 by
No,
26.
26 application is not here. Bring it. On the next day, record is a submission that he has filed an application for amendment of the writ petition being I number.
27/26.
Record it. It is submitted by such a that I have filed. There is clear. Stop. The same is not included in the cause in the brief in the record. So let the department tag the said applications to be listed.
Item number 8.
Yes.
Now it is particular
What illegality, madam?
systematic fraud, my lord, is evident.
When you appear, always it is a fraud, malice, malafide, coercion, undue influence.
The documents marked it where how e-tender and they are doing it manually and everything is there, but still I will draw your lordship's attention. My lord, there is a transport of food stock in the transport of food stock in transport contract transporting agents there in Gajapati district. There is a tender for transporting the food stock through SNP under SNP Supplementary Nutrition Program through Anganwadi. My lord, kindly see one point, page 23. There was a tender passed. That tender cancelled for no reason assigned, but page 23. My lord, that's 8.
Attested copy of the valid registration number.
And the petitioner's license is there, annexure 3, my lord. Kindly see, page 24. Next. I have under Carriage by Road Act 2007, Carriage by Road Rules
Yes, yes.
2011. So, my lord, when I have applied in the second tender, there is a clarification by the chairman of tendering committee to the RTO, Gajapati, that whether my license can operate, whether my licensing agent and licensing authority is Khordha Transport Authority, whether that can be valid in the Gajapati district. That can be throughout the state. Earlier, my lord, throughout the state only STS, Commissioner, State Transport Commissioner was issuing the registration license for all the state to operate within the throughout the country state. Then it is modified in 2007. Then also the state RTO can also grant it. My lord, but how the fraud I am saying, my lord, kindly see Annex 4. That is the Gajapati has given the clarification without referring the rule. In mentioning in the rule 2 of H, I, in relation to an agent's license to be operative in more than one region of the state, but he cleverly didn't disclose the rule, 93 rule, that is repealed. The RTO has referenced a rule in 2025 which is repealed, just to cancel this tender. My lord, thereafter, my lord, kindly see. On 27 Annexure 5, there is a 27/5/2025 that for opening of the tender, everyone was there and
But the subsequent tender was floated.
floated. That was stayed by this honorable court. Stayed by this honorable.
No. Subsequent. This is the earlier affair.
Tender. First tender was cancelled.
Was cancelled. Then second tender.
Second tender, I have participated.
Yes.
It is cancelled. But somehow they want to cancel it because they need.
No. They have cancelled.
This tender was cancelled.
Correct. Then why?
Then
Why?
tender was.
Third tender.
what
Say
is
that. Third tender floated.
Floated. That
Yes.
final.
You participated.
No, because
Why?
their solvency is 1 crore from 50 lakhs.
Say that.
So third tender is not still, my lord, seen the light of the day because we have this honorable court has that.
Correct.
My lord, this was, my lord, kindly see why I am saying this is
So
fraud.
what will have? Suppose if we declare that this objection was unjustified, but ultimately the tender is cancelled, the third tender has already been floated. What is it? That's all. So what you will yield a result?
My lord, that's the after our objection, that clarification collector has called for the clarification annexure 11. That is page 44, my lord. The collector has from transport commissioner come chairman, the collector has sought for a clarification. In that clarification, the STA has stated that transporting authority constitution of 68 in the
Where he has a hence necessary clarification be given
page
that the registration certificate issued by STA and RTO are equal or not, and early clarification is highly solicited. Then what clarification?
There is a clarification under RTA to have obtained everything. Registering authority means a state
So
transport.
that is the definition they have quoted.
My lord.
So
And regional transport authority.
So-
Then my lord, 2015 letter they have given to all RTO that all RTO's license.
sir, understand, madam, please try to understand what is playing in our mind.
My lord.
What you are saying is first tender was cancelled, the second tender was cancelled also. They have quoted a particular provision relating to the grant of the certificate or the license, whatever.
That is repealed.
That's there of a repealed act
My lord.
or a rules. Anyhow, the third tender is also floated. The third tender is a subject matter of challenge in this court. The matter is pending. Order of stay has been granted. Now you are falling back to the second tender. You are falling back to the second tender, which has already been cancelled.
Let both the matter be tagged up and.
Sorry, we can't.
My lord, because
Sorry, that you take a plea, third tender will be considered. If we take a decision, then what will happen? What will happen? The ground on which the second tender was cancelled. Maybe we say that this can't be the reason for that, but there is nothing which the reason is coming there from.
My lord, they are giving that reason.
What reason?
My lord, kindly see Annex 6, page 27.
Nothing has been
My
given.
lord, that is that. In the tender notification in Annex 2, page 27, Annex 6 on 29/5/2000.
So they have said that on due discussion on clarification received in correspondence, we invite immediately.
And that is hereby cancelled. My lord, because of this, because of
Page 27.
27,
Where is the
the
decision?
the tender notification invited by such and such is hereby cancelled
Correct.
after due discussion.
Correct.
Clarification received, which is a on repealed route
Correct.
from the active Gajapati in correspondence to White letter.
So suppose if it goes, then what will happen? Just you tell me. Will be opened
Open.
and third tender will go.
Oh,
So let the third court decide that writ petition.
my lord, because
Why will
I am saying because,
why will decide?
my lord,
You must have taken that plea in that writ petition. That they cannot float a third tender after cancelling the second tender because the cancellation the reason for cancellation is wrong.
yeah.
So the court will decide there.
My lord, now because of the clarification, time is going out. Because of the clarification, my lord, that is the fraud and some there how they are playing it.
Madam, you could have you have raised that issue in that writ petition.
Saying, my lord, both men be tagged and disposed
No,
of.
now I am out talking about order 2 rule 2.
My lord,
Tell me of the Code of Civil Procedure.
see this.
Order 2 rule 2. I'm talking.
My lord, this is the petition.
Yes, so the Code of Civil Procedure's principles will not apply.
My lord, my lord,
Then section 11 res judicata in a writ should not apply. Then any principles of law relating to procedures will not apply.
no, that's I am not submitting. But kindly see Annex 8 for a moment, kindly see.
You could have essayed this everything in a third. That is the foundation of the challenge to a third tender.
Then I have stated everything. My lord, Annex 8, my lord, kindly see.
How can it be?
For a moment. I know, my lord, because that is well pending. My lord, Annex 8, my lord, for a time. That is third tender issued on
Page?
page 29. This is the third tender.
Yes.
That been signed by collector on 28/5
Yes.
and issued on 29/5. And
Yes.
ADM was called for us on 29/5.
Yes.
Same day. So I am saying this
So-
is already decided that they will go
Madam,
for third tender.
that's I you say the dichotomy of this. If the authority delayed in taking a decision, you have a problem. If a authority takes a prompt decision, then also you have a problem. What they will do
My lord, corruption is a dead giveaway in the tender.
is not one incident does not mean that all incidents are bad.
My submission is my lord, for a moment. My
We are
submission.
talking about the law proposition of law. When you have challenged the third tender, your challenge is founded on the assertion that the order cancelling the second tender is wrong.
But now
Then how can you file this writ petition challenging that again?
that I am not challenging.
Then what you are telling?
Clarification come from the STA that I have a valid license. So that second tender may be
Maybe
acted up.
maybe
Maybe acted upon. I am not.
that means then what to the court will say
I
that the reason for cancelling the second tender is wrong. That means what you have to achieve in that writ petition,
no. I
you are trying to achieve in this writ petition. No.
Miss.
Then order 2 rule 2 satisfied.
Well, both may be tagged up.
I am asking you the proposition of law, order 2 rule 2.
My lord,
Show me.
My submission is, I do understand, my lord, my submission is, hat tender, I have prayed for passing of hat tender. In that.
Do one thing. You take out a plea of section 10 of the CPC, staying this particular the proceeding until that decision is taken
But that
in the earlier writ petition.
But that is the exactly, they want that because their own, near and that own people is continuing with the tender. So by that way, they are showing a favor to those are.
Madam, please try to understand.
Yeah.
You have already secured an order of stay of the tender so far as third tender is concerned.
Sir, but I am on second tender after clarification.
Madam, after clarification, they have sought for clarification. The clarification has not come.
They have clarified my.
What clarified?
That this is, I have a valid license, but they are not opening it. I have a valid license. So collector, they have clarified it.
Then why you are why you are aggrieved?
Opening it because of the stay continuing in order.
But in the meantime, the cancellation has done. The second tender is cancelled.
And that is stayed by the honorable court.
Order of cancelling the second tender is stayed or a third tender is stayed.
Third tender is stayed.
So
cancellation, this cancellation will go. My lord,
madam, probably our wavelength is not matching.
No, my lord, your lordship is always right. I can't say that. But my problem is, my predicament is.
Sir, the problem is that you are not really considering and opening your door too wide so far as the door of the mind is concerned. Please consider, I am again beseeching before you. First tender was cancelled. Second tender, which was invited, is also cancelled, maybe for one reason or another, which reason is bad, indifferent, whatever is there. Now they have floated a third tender. In a very simpler way, I am putting it. As a lawyer, third tender is floated. You challenge the third tender. Must be on a ground that the reason for cancelling the second tender is illegal beyond the settled proposition of law. Because they invoked a particular provision of the statute which has already been repealed. That is the challenge to a third tender. The court prima facie found that your contention is correct, stayed the third tender. And fair enough. Now in the meantime, so far as the clarification is concerned, which impinges on that ground, this says that yes, that can be done. You are challenging. That means in this writ petition, what the court will decide? That the provision which they invoke for cancellation is justified or illegal. If the court has to declare that this ground of cancellation is bad, if the court declares the ground of the cancellation is bad, that means the second tender gets revived or may not revive. May not revive. Then what will happen to that writ petition which is pending and a stay has been granted to a third? Automatically it will go. If you have already approached and this point which you have raised can be decided in that writ petition, why there will be a multiple proceedings? I am on that. You can raise all these grounds which you have taken in that writ petition. You have already done. And you wanted to tag. Why should he? You wanted to rely on certain documents, make an amendment and do it.
Caught me in the right fight, my lord. I hate that.
So this is what I'm saying. Why you are troubling in this?
Dixon 9.
You go there. That's the main challenge which is there.
The time is up to March.
Whatever.
Dixon 9, page 30.
You go there, get it listed there and get it decided.
Page Dixon 9, my representation before the collector may be disposed of in this writ application.
We will say that pending the writ petition, they will not touch. We'll make, don't worry, we will make certain observation which would make the representation absolutely academic, nothing more than that. No, sir. No, madam. I have this multiplicity of the proceeding, I have a strongest of reservations. is good for the member of the bar, but not good for the.
Because of the time limit, then on March it is going to complete.
That can.
But-
They are all these points which she has raised in his petition
There also.
amenable to be decided in both. Another exception, which is pending.
Is there
The
also.
order of stings. Obviously,
Then I do.
it has to.
My lord, that's okay. My lord, I do. Because of the time is not there, it is not.
You-
Notice,
Sir,
my lord, that's.
Madam,
Compared to
Madam, what is the latent intention is very much patent to us.
I'm so, my lord, I'm a infant.
Is very patent to us. Why you wanted this writ petition to come?
But only to dispose of, that's not.
That is what is the intention.
It is my-
You cannot get it, that writ petition so hurriedly done, you wanted.
Lordship, when touching the file knows the intention of the prayer. But only my case is that let it come, my lord, at least along with this.
That you mentioned you will.
This writ petition.
No, you withdraw and you mentioned that we will consider.
But that's after notice matter, that's.
Yes, so what? So what?
It's
We
not-
are taking up after notice matter. So
But my.
no difficulty.
My lord, my lock is not getting.
No. Luck is,
Yeah.
don't believe in luck, believe in karma.
That's right, my lord. From December.
Rather than it's like there are some minutes I'm appealing to cabinet mail from the development of it. The cancellation of parental agreement. No, but
Whatever, we are asking for a Passover.
I'm sitting seriously, my lord.
Come on the next week. Math.
No, this week, my lord.
Yes, item 10.
Let me see the use of refund of PMD amount where the tender condition provides once you unsuccessful on the application of the unsuccessful bidder, the AMD will be refunded.
What are you doing, sir?
2024 I am unsuccessful.
Why are you not doing it? He is an unsuccessful tender.
Yet we want to refund it,
Then,
but he has closed his bank account.
sorry,
The
take a instruction. That is the C is the.
blank account, Millard, I have the bank account which says, they say, no, I have already other bank account I provided. That's,
Where you have
Millard, I
communicated?
have my friend Amita Ali. I have,
Where you have communicated?
yes,
So,
Millard, that annexure 4, 5, your lordship, can you see? Millard, I-
So, page,
Page, your lordship, can you see from the beginning, your
page.
lordship, page 115, your lordship. Millard, 1400 is repeated.
Oh, he has already communicated to you and your,
Let's see the install.
whether you have received this letter or not.
There is a seal below 114 page, your lordship, can you see? Chief engineer seal.
Oh, yes, he has already given way back in the month of February 2025. And there is a seal. So,
Let's for the predicament is that Miller.
what predicament?
Let's see, kindly see the installment.
What?
Actually, what happens here? When this amount is automatically deposited in the portal here,
Hmm.
it is deposited, actually it goes to another account. That is maintained by the government.
Sir, I tell you, is it mandatory that a person must retain that particular amount, account from which they have credited that particular amount to in your account?
That
If they have subsequently said, maybe a reason that they do not want to continue with this account, if they have said, and if you can identify that this account belongs to him, where is the difficulty in remitting the amount?
actually that money is to be refunded from that portal to that portal.
So portal, when they have said that there is no restrictions that you have to remit this amount to the same account from which it has been credited in your account. Why?
Paragraph 8. The authority wants some time to find a solution.
It is an automated system.
This is not an automated system. You'll have to instruct. What is everything is a tailor-made.
if suppose automated system he has written, but suppose that is blocked or that is not operative,
Yes.
he has furnished you the information
That's why.
to which it has to go. You have to simply verify whether he is the person or not and transmit it.
Yes, ma'am. To that effect, that
That doesn't mean that you will withhold and utilize that amount.
and
You are directing to refund with interest. Unreasonable.
Actually, there is a notification of the government.
What notification?
That's a kind.
Is absolutely, I would say, unreasonable notification.
Because
Unreasonable notification.
but if make you want to 2 weeks time maybe grant.
What 2 weeks time?
Actually, they are working on that.
I do not want to know anything on it. Next week as a first matter to be mentioned. Come on that day. If you cannot, then we'll direct you to remit the amount.
27.
No,
27.
sorry.
Item 11.
No, it's not expected.
Say, instruct your officer that he has intimated you that.
Just you verify that this account belongs to him or not. That's all.
Item 11.
May I please your work? You know, to kindly come page 13 annexure 1. My technical bid has been rejected on the ground inactive GST
Page?
wrong application.
Page
Page 13 annexure 1.
13.
13 1 3.
Yes.
My technical bid has been rejected on the ground inactive GST and wrong application.
Yes.
Your Lordship may kindly.
On a technical ground. What is your name?
My name is
Nilambar. Nilambar serial number?
Serial 2.
2.
Mila.
Inactive GST and working and wrong affidavit. Yes. Then
Both have.
yes, there's a good ground.
No, my lord, both I have a valid GST. Your Lordship may kindly come to page. Page 40.
40.
40. 40.
40.
I have valid GST.
Where is that? Yes.
Sorry, my lord, 38.
Huh?
Annexure 4, 38. Serial number 8.
Validity.
Type of registration regular.
Huh?
Serial number 8, your Lordship.
Huh?
Type of registration regular.
True. Whether on the date of participation, whether it was
My lord,
there or not in 2025,
it was regularly filed before the GST.
you do not know if you have submitted the return periodically and if they have not suspended or registered.
The document which I have submitted before this report and same has been submitted while the technical bid has been before the technical bid has been opened.
Yes.
All the documents are correct to the your Lordship may kindly come to the tender call notice under annexure.
No, where is your affidavit also?
Affidavit is there, your Lordship. Your Lordship may kindly come to actually may kindly come to page 51. That I have filed all Xerox copy of all original documents, namely C-class contractor license, so valid date, PAN card, GST, EMD before the executive engineer and lift irrigation division, Karanji for execution of following work in response to the tender call notice, so also approved.
Yes, but what is the reason? If it is an active one, then
Orissa Lift Irrigation Corporation had a separate council representing the corporation.
so why you were keeping yourself away?
Is it the Vinama? Yes.
So you could have come. No? Why you were just sitting behind and then waiting that what the court will do? Serve her a copy.
Yeah.
So next week, take instructions. If it is record, what is the name? Record that. Yes. No? Yes, on the next available date.
As per lift irrigation.
Copy in course of this day.
Yeah.
So take instructions and come back. Exact reason.
Item 12.
So
Maybe.
plus additional common council.
Here the dates are important, Lordship. And more especially, I'm challenging Annex 3, Lordship, of page 27 by passing a banning order, Lordship, on me.
20?
27 page, Annex 3, page 27, Lordship.
Just 1 minute.
That is 212.
Just.
Sorry.
What happened? Did you submit the reply?
I have already submitted.
Where?
Okay, Robert Smith, Lordship.
Just. Let me first clear my understanding. Where you submitted?
Lordship, in fact, Lordship, prior to that, they had issued me so-called action. They had issued me so-called before taking such action. They had.
But now the subsequent so-called notice is issued on 12/8.
Lordship.
Yes.
Not
Then-
so banning order, Lordship. They passed a banning order in considering my so-called Lordship.
Sir, I am asking you, subject is banning of the business dealing.
Lordship.
And they said that we are anticipating your reply by 19/9
Lordship.
and thereafter take a
Lordship. Please find it is requested to issue necessary access to all concerns under your in this regard.
no. Then did you file on 19/9 or 26/9?
26/9, Lordship, I had filed.
Where is that?
20,
Sure.
Lordship, that is on Annex 6, Lordship. Lordship.
Page
8-9, Lordship, that is.
page
33, Lordship.
18/9.
page 33.
33, Lordship.
Yes. Reply to show cause. Yes. Yes. Then what happened, sir?
Lordship, here, Lordship, the leader considers they have.
No. You have given. Then what happened?
Lordship, no, my humble submission, Lordship, kindly say.
What happened thereafter? After
Thereafter,
receiving the reply,
Lordship,
what happened?
8-9, Lordship, they have, Lordship, come up this, Lordship, they have communicated this order, Lordship, to their all concerned.
Where is that 8/9 order? 8/9 order is at what page?
Lordship, that is. I replied pursuant to the focus 22-8.
I understand, sir. I have seen that. I just wanted to know where is the decision they took on 8/9.
Lordship, that order not never been communicated to me, Lordship.
So they might not have taken that decision.
No, 8/9. Here held on 18/9.
18/9. They
18-9.
have to take a decision.
On 2-12, Lordship, that is Annex 3, that is 2-12-2025, Lordship.
Page?
Page 27, Lordship.
Yes.
Annex 3. Now they have taken decision for banning of my business, Lordship. For
No,
2 weeks.
where is the decision? They have simply says that the letter is annexed.
Railway board's letter is self-explanatory.
That is what is they wanted. Everything is there. They have given providing an opportunity to hear them in persons in the board's office.
I'm not on that, Lordship. I'm very simple, Lordship.
There is no order of banning.
That is order banning, Lordship.
Where is the order of banning?
Lordship, may I read once again, Lordship?
Please.
Lordship, banning of business dealing with Messrs. Lakshman.
That is the subject matter.
Subject matter.
That is a show cause. Show cause must clearly show that for what the show cause is issued. The show cause is issued to ban you from any future dealing.
Lordship.
And they invited you to file a reply. They invited you to file a reply and then say paragraph 5 that an opportunity personal hearing shall be given to you. I'm just asking where is the final decision taken?
Paragraph 5 of that. You see, paragraph 5.
At least 28.
Lordship, I'm referring to page 27, Lordship.
Please, 27 does not speak of anything.
Paragraph
Please find enclosed herewith a copy of the railway board's letter such and such on the subject. It is requested to issue a necessary instruction to all concerned under your control. enclosed herein above. Nothing is coming out whether the order of banning a business drilling is passed.
In fact, Lordship, in person to test 28.
Where is one sheet? It is a one sheet.
Para 5, you see para 5 of that page 28. It's very
Oh,
clear.
yes, sir. What I
So
find
that is
here?
on
You
12,
come to page
8 not
27.
impact. Then Lordship,
Page
it should show
27, reference.
8.
There is another letter which he has not received. He has not annexed.
Yes. That is not up.
That
Lordship,
ED,
on 20.
That is 112.
32.
That is 112.
11225.
That letter he has not received.
That is not available with me.
What are you saying? He is saying one sheet.
That is not available with me, Lordship. They only given this letter.
Where is that letter of 112?
This letter is, I have to take instruction, but here
Next
it
week.
is not an.
Next week.
Plus, careful.
One week after, so that I can
Next
take-
week. You come with this letter.
In the presence of para 5, you
No, I
could, take any,
understand.
you could not take any coercive action till
No.
final decision comes
They
out
are giving-
after personal hearing.
So come with this particular letter. You have said annex enclosed one sheet. What is that one sheet?
Fine.
Come with that. That's all. We want it next week.
At least 10 days time maybe.
No. If you can do it in 10 days, you can do it in 7 days. Yes.
Item 13.
Makes easier lot. This small typographical error at page 28. Small typographical error at page 28. The Lordship may permit me to correct that. Instead of annexure 7, 6, it has to be annexure 6.
Yes.
But here,
Yes. Prayer is not a part of the affidavit anyhow. Yes.
on page 210, the petitioner participated and was technically qualified. Your Lordship, the page 210 is a technical proceedings of the technical evaluation.
Your serial number is 2
I am serial number 2,
in page 211.
211.
Fulfills the eligibility criteria as per laws of the DTCM. Yes,
Yes.
qualified. Then
Thereafter, on the next page, 212,
uh,
price bids are open. My price is the lowest.
BMS.
Serial number 2, I am minus 14.99.
Yes,
I am the lowest.
correct. Then
Instead of issuing me the work order, they do a second technical evaluation and disqualify me. We are page 213, page 214, I get disqualified technically. This is without any intervening opportunity as to why. They were again a technical evaluation was done.
so now what is this 8A, B, C, D clause?
Yes, Bharat.
Where is that?
Now the
And
clause
D.
is, at page 68, balance. 68A1. If your Lordship has that. Fourth line of that clause 1, 8AI, it says of electrical installation, let me read it from the top. The civil contractor, in order to take.
So this was nothing related to a quoting of the price. It has got no relation
Nothing, Malak.
because there are certain conditions that you cannot quote less than this much of percentage or something.
15%, that is the.
You can't go beyond
No,
that.
it is not on that. It is not on that.
Then how can we get once here? Yes, can we justify? Can you take a review? The technical evaluation was already done before the financial one, and you have found him as an eligible. Then how can you fall back after the opening of the financial bid and say that he is technically disqualified? That shows some kind of a undercurrent.
The undercurrent is this, the difference is 12 crores.
That's the kind.
What's
Yes, I'm sorry that I'm having one professor. I have marked proportion. Why it is done?
Can you do it? I am asking you. Marking will not do.
Actually, Miller, the document which is submitted, Miller, all were effective documents, the first party.
Sir, what you were doing at the technical evaluation? What for the tenders are divided into two components. One is a technical, another is a financial. In a technical, will you not scrutinize all the documents and then say that this is what? The moment you found that he is the lowest bidder, then
One Jagannath Mahapatra, on the same day he made an allegation.
made an allegation. So you will do it. What you were doing? How can he get an access to these documents? The Jagannatha?
He has also
This is maybe he has submitted a technical bid. Is it open? He has submitted all. Are you giving the bid documents to all?
But it is uploaded in the portal.
After the technical evaluation is done, did he raise an objection before the financial bid opened?
It was raised on 11/12.
And when the financial bid was opened?
Financial bid was opened on 19/12/2025.
How can you open the financial bid?
No, 12/11, the date is
12/11. No,
On their
12/12.
committee.
no, he's saying 12.
12/12, the date is
12/12.
given.
It is written in that date chart. It's kindly have a glance.
What are you talking about? 16?
19/12/2025. It is page B. Financial bid was opened wherein opposite party number 2 became the L1 bidder. 19/12/2025.
That is the second time.
That
That
1912.
is the second time. First time he is talking about. This is a page 212 when it is opened. When it is opened.
At page 212, the third line from the top. At the header. Date is given, time is also given.
Time was 12 December 2025.
Where 12 December 2000 at 12:13 p.m. So
And before
how can you come to know of this? How can you come to know of this price?
before that, complaint was lost on 11 December.
Then what? Why you opened the financial bid? Why you opened the financial bid? They have proceeded on this basis.
Yes, today I have given an affidavit, they have called him for execution of the agreement.
How can it be? How can it be? And it is burdening the exchequer by near
12
about
crores.
12 crores. What is the purpose of calling the tender?
ABCD are not related to financial.
No, it is not. The,
8 ABCD is not relatable to financial aspect of
Technical aspect.
technical aspect.
Technical.
So
I need to file an affidavit because why it was not done.
His signature, as he says, was not there. He's talking about the signature parts. Understand?
on one document only, which I have uploaded, the signature of the other party is there, my signature is not there, that is the allegation. And my lord, there are judgments, OPS judgments on this point, which say that the fact that I have uploaded a document shows that I have a consent to it.
And that is related to.
is it a condition precedent anywhere that each page has to be signed?
No, nowhere it is written.
No,
MOU
some details here we have seen. We have seen.
Here, there, on the contrary, my lord, if that was my signature was missing on one MOU, there is a provision in the contract where they could have called me for a clarification. We have submitted, that is at page 47. That also they have not done. page 47, 85, 8.5.1.
No, no, this is of a historical nature and all everything. That is a different. Where is a PSS? That is the evaluation at the first. All the open books shall be downloaded and printed. The officer authorized to open the tender shall sign and number on each page and furnish a certificate that the document is available, numbers of pages. How can you do it? How can you do that? Have you made that successful bidder as a party?
Yes, that's made him.
Notice has been served on a.
Notice not received.
Today is the first time. Today, in fact, I've given the affidavit that they are proceeding with.
Brother, this is a fit case for me. I believe. This is a fit case for me.
because
Not,
only, yes,
not precedes,
Which each section.
which shall be followed with the execution.
which shall be followed. Agreement has not been executed.
But you said it is going to be executed.
Going to be executed any day.
He only appears at paragraph 4 meter.
I'm very particular about recording the reasons, Mr. President. When I pass an ex parte ad interim order of injunction, I have said that it is my duty to record the strong reasons that why the delay would defeat the purpose. Bearing in account Order 39, Rule 3 principles. I'm very strict about it.
Yes, that document is there, Annexure 9, your lordship, today's affidavit, if your lordship sees. Today's affidavit, I have given that affidavit. Page 3 of that. That's a document by which he has been invited.
Are you going to execute the agreement today?
Not being executed today.
True, but are you going?
This stated in the intent of the person that the work is going to be awarded in his favor today.
It is out. The petitioner apprehends that the work order would be issued to the second lowest bidder at any point of time, as he is called for verification of the original documents, which is sine qua non to the issuance of the work order. Don't say yes. Don't give the wrong instructions to your senior. That's the difficulty.
5th January. So it is gone 1 week ago.
So it has gone. 5th January has gone.
That is verification of
Documents and thereafter.
Verification of original documents were to be held on or before 5th of January. That is gone.
So
Another
what
1
is
week
now?
has already
1 week
elapsed.
is also elapsed.
My instruction is work order is not finished.
Not this.
That is the problem with the instruction.
But that is not the affidavit, Mr. Siddhant.
The petition is written that
You have furnished this document, knowing fully well that on or before 5th January, the documents were.
State is aware.
No, we will not pass an interim order. Question is not the action is to be quashed. Is a different. The question is an interim order in absence of a party without giving him an opportunity of hearing. We are at this stage. Then we will simply say the issue notice, no interim order at this stage. That's all. Let him come back, we'll hear. Order 39, Rule 3 principles. when the affidavit is likely to be filed or is filed, will you not state that?
It ought to have been.
Then
It ought to have been stated that
that to the best of the knowledge or information, the agreement has not been executed.
maybe it's not very happily worded, but
No.
3 and 4 together actually mean that.
No, does not,
Paragraph 3 and 4,
does not.
it has not been very happily
No.
worded. Whereas your Lordship's Excellence in English is not.
No, is not, because it's a very simple one. One has to understand.
Yeah, I do understand
What is this?
what is holding back your Lordship, but the fact, if your Lordship will just.
File an affidavit at 2, otherwise we'll not.
Yes, ma'am. We'll come back with
What else?
Get the instruction whether it is executed.
Over the telephone. Just keep it. I will have it dictated there. Yes, pass over for the time. I will dictate there.
Item number 14.
Three days means 5.
On 6th, he has appeared before the authority because he received return for that reason he has appeared before the authority by doing the bank guarantee and fixed deposit, my lord.
But you asked for 15 days.
I am coming to 6/12 when he appeared before the authority, they told that you bring 2 vehicles in your name because he has submitted the tender. He has 2 vehicles in his name. He qualified in 2 units. For that reason, he can give lease vehicle in respect of other unit also. But they told that you bring 2 vehicles in your name only. For that reason, he asked 15 days time to give it. By 15, he will give it. The documents relating to the vehicles, he will give it. And on 15, he came along with all the documents. Your Lordship may say he has done the bank guarantee or the other fixed deposit on 4/12/2026.
No.
25.
What is the nature of the tender? You have to, correct. Then you will have to disclose the registration number of a vehicle.
Yes, I have disclosed for that reason. I have been selected.
Correct. So you have disclosed.
Yes.
Now you disclosed in another tender the
Yes,
same
ma'am.
vehicle. Now you have already attached that vehicle into that
Before
tender.
the same authority. Before the same authority.
Whatever. So
I have to give 2 leased vehicles again, my lord, for this. But they have told that it should be in your name. For transfer of the name, my lord, it will take minimum 7 days time. For that reason, I submit it within 15.
So whatever, they have cancelled.
My lord, on what happened, my lord, on 15 they did not receive it from me. So the petitioner sent it through court.
Then,
They received the same on the same date, my lord.
yeah,
Annexer 7 series, my lord. All the things are there, my lord. Your lordship may see the page 125. They received it on 15/12/2025.
and on the same day they have cancelled.
Same day they have considered it is received by the petitioner on mail on 18th. Next page 128, my lord.
Yes, what do you say?
Instructions for this matter. From the record, my lords, at page number 94, initially they had to submit all the details by 24th November 2025. Page 24th November, my lords.
2025,
my lords.
So how can you terminate prior to that?
No, but it's after.
15 December.
Yes, but 24th November, my lords.
Oh, November. You say December.
Page number 94, my lords.
But how, if you have extended it then?
Only once, my lords. It was extended till 5th December.
Correct.
It was extended, my lords.
Correct.
And there is a clause in the contract, my lords, at page number 44, my lords,
Yes.
15.6. The agreement shall be executed within the time prescribed by the district manager, failing which the contract shall be liable to be rescinded solely at the discretion of the district manager.
Correct.
In such case, earnest money of the bidder shall stand forfeited at the discretion of the
Right.
manager. Accordingly, when it was not submitted within the stipulated time, it was cancelled on 51 minutes. I can hand over the instructions also. Ma'am.
But he has already approached and he has been given a chance
Well, it's,
to give that particular leased vehicle in his own name.
well, it's first after 9/17.
That is what is the statement in the writ petition
Yes,
where
yes.
stated.
Yes. And the condition also states that 7 days time should have been given to give the detail of the vehicle, my lord. And the agreement should have
Where you have stated.
My lord, your lordship. Your lordship, they are referring to 15.6.
I am asking
Yes, ma'am.
you your statement in
Yes,
the
ma'am.
writ
Yes,
petition,
ma'am.
sir.
Yes, ma'am.
Where you have stated.
Paragraph 10, my lord. Paragraph 8, 9, 10, my lord. That it is humbly some paragraph 8, page 7, my lord. Paragraph 7, I have stated about the submission of document, and thereafter paragraph 7, my lord, paragraph 8. On 15/12/2025, the petitioner has submitted the relevant vehicle documents along with
Just.
That is 16.
But you have not, what you are arguing is something different than what you have stated in paragraph 7.
Paragraph 7, your lordship.
No, you have not stated that in the meeting when you came there, they told that it will not be a leased vehicle. They wanted the vehicle should be in your name. Where is that statement?
Your lordship, can see the agreement within 3 days positively, the petitioner has done the bank guarantee on it. And further time and execute the agreement, allow further time to vehicle document. The authorities told that the agreement will be signed after receipt of the vehicle documents.
What is the meaning of the vehicle document? That means you did not submit that particular document relating to the vehicle which you disclosed in your tender. That means the fault on your part.
That is there with them, my lord.
I am again asking you, sir, you are saying something. That's a very interesting part here. What is not stated in the petition is argued at the bar. Dehones the record.
Paragraph 10, I have written.
Please, again I am asking you, sir. Paragraph 7 I did not find.
That it is humbly submitted that the above office order has been issued passed without any basis, and though the petitioner has submitted all documents along with the bank guarantee and demand draft.
That was beyond the time.
Thereafter, before the district manager CSO for that, the petitioner had the bank guarantee on 4/12/2025, but he has not been allowed to sign the agreement and asked the petitioner to submit the documents of 2 vehicles.
Yeah, this is what I really wanted.
So the petitioner, as per the condition of tender, has asked for time till 15/12/2025. After receipt of the letter of the petitioner, nothing has been communicated to him. So it is.
So what is your answer to this?
Page number 94.
You have written only one line. You have not stated about receipt of the compliance by 15,
Yes, my lord.
but you have written one line. Till cancellation, no complete documents have been received from the petition. That you will show.
If your instruction is that they have to submit the document that the vehicle is standing in their own name, and then they ask for 15 days time, then how can you fall back?
Page number 94, one.
And this was not a condition in the tender,
Page number 90.
that it must stand in his own name.
The lease vehicle, ma'am.
So,
Page number 91. What was required was bank guarantee, also serial number 4 minus.
that was given to him, that was given.
He had to submit the documents registration under the motor vehicle.
True.
Yes, my lord.
He says that I have a document registration certificate relating to leased vehicle. He has taken on lease from the owner of the said vehicle. But this statement is that you insist that no, I do not want a lease. It must stand in your name. That means you are the owner, you should be the owner. He asked for the time till 15th. And then before 15th, he went and submitted all the documents. This is a statement on oath. And where is the insistence?
There is no document to show that there was an insistence as per 1711 at page number
He had not enclosed the lease document. He did not.
That is the
Lease
requirement.
document.
Then how you permitted him to participate?
The requirement and the office order was for serial number 4 minus. He had to submit registration under the motor vehicle. That is the requirement.
Sir, madam, probably you are not understanding the issue. Once the tender conditions are that he has to disclose the registration number of a vehicle which he wanted to place. It does not stipulate that this vehicle must be owned by them. If he has taken this vehicle on hire basis, that is on a lease basis, then he can definitely do it. His contention is that I went with the documents within the time, but there was an insistence from your end that no, all the vehicle must stand in your own name. So he has to purchase the vehicle in his own name. He sought for time till 15 so that he will submit the documents. He purchased it and submitted the document within 15. Now he has said that since you did refuse to execute the agreement on that score, then how can you cancel?
The replies which he had submitted to the department does not mention that. At page number 96 and the 98 are the letters which he had submitted to the department.
Then what is the necessity of a pleading to be made in a judicial, right?
That was never.
The pleading of the fact on oath to be the correct. Then
That is instruction, my lord, because there is no document to support that. Even page 96 and 98, where he's asking for time, he does not mention that, my lord. So
No, ma'am. In 98 it has been written.
he has asked till 15th.
And my lords, one extension was given, because given extension till 5th December, my lords. After the request was taken, was given extension till 5th
Have
December.
you rejected? Have you rejected?
Yes, my lords.
Have you rejected his prayer for further extension?
My lords, as per office order at annexure impugned
You have not
annexure.
said that. Your written instruction is otherwise.
My lords, as per the clause, my lords, the discretion
till
of the district
cancellation.
manager whether they want to extend it or not. My lords.
So according to you, any weird discretion is immune from interference by the Red Court.
And this, as per the clause, this has been done, my lord. That is my.
Sir, once the discretion is, then the discretion must be exercised reasonably, rationally.
First office
You can't exercise the discretion whimsically.
order, I agree, my lord.
So-
My lord, the first order was.
If he says that he was ready to execute the agreement within the extended time, but you deny the execution, raising a particular issue, and on that basis, he asked for a time.
Only to that government, my lord, if I may get one chance to take instruction, my lord, only to that government, my lord. Because at what.
Paragraph 10 is said that in terms of the aforesaid order and with such and such, petitioner submitted all the documents. Even made a bank guarantee on 412. Why he will not submit? A bank guarantee which is taken on 4/12, within 5/12. Give an affidavit by 1 week. Let them come with us, dealing with this part of.
I think Civil Supply Corporation is. We are a.
No, it's notice of support money, but.
I saw the copy on Mr. Withdrawal.
It is matter.
You are appearing for the state. That's all.
I saw the copy on Mr. Mishra, senior.
Not similar. I think.
How can you directly go to the senior advocate and who will receive the copy? He is not supposed to receive the copy and act like a advocate and record.
I can say that
Miss Mohan.
Miss Marti or Patro.
Mr. Jagjivan
Mr.
Pradhan.
Huh?
Mr. Jagjivan Pradhan.
Jagjivan.
Complete. What is this matter? This is item number?
Item number 14.
14. 2 items are there. Let us see 15 and 16.
Item 15.
Affidavit, we wanted you to file affidavit with this one.
Yes, sir. So,
I will saw the copy. Any of them.
not
And-
again, sir.
Somewhat.
Ms. Tripathi was.
Yes.
Item 15.
They are also in the past.
There is a clause for turnover. There is a clause for turnover.
Also conditions of page 15.
15.
Row 3.
How much turnover?
20 lakhs per annum.
Per annum.
Madam. Last 3 years, madam. The only
Yes.
confusion is there. The last 3 years, the technical bid was called for in the month of September 23/9/2025, madam. According to the last 3 years, should be 22, 23, 23, 24, 25, 25.
True.
However, they have indicated 21, 22, 23, 23, 23, 23, 24, madam. The petitioner matter submitted turnover statement at page 18 annexure 2, madam.
No, I have seen 22, 23, 23, 24, 24, 25. Because the financial year of 2025
Madam.
ends on March and the tender was floated after that.
Madam.
Then when it was floated?
24/10/2025. Open, madam.
24 floated means when it was published.
24/10/2025.
10. Okay. By this time the return must have been filed. Yes,
Yes,
I was
yes.
thinking in that. Yes.
Page number 15, madam.
I've seen.
The years are extended, madam. 3 years means starting from 21, 22.
Yes. I was appointed. Yes.
This is the next file.
Once they have indicated the financial year, you can't take a shelter that it is a preceding 3 financial years. Once they have identified, you cannot vary of your own or perceived something of your own.
I'm reminded of.
No, sir.
My own, I was party to the judgment which is set aside by Honorable Supreme Court, saying that what she says is correct. Just
For last 3 years does not mean once they have said that what would be the last 3 years, then you'll have to follow that. Had he not indicated the year, financial year, your position would have been different. Once they have indicated the financial year in the bid document itself, then you'll have to follow that. You can't.
I think to clarify, they have put it
No.
after Supreme Honorable Supreme Court judgment, they have clarified this.
No.
That's what. No.
There are two factors which I
Written
balance sheet is to be filed.
PB, PC, they are clarified.
No, sir, that can't be done. If they have given a year, financial year, then it can. Had it been a case that they have not given a financial year, I would have understood.
Is some success, my lord, that they have indicated, but that's not, there is a gap, my lord.
What is the gap?
My lord, last 3 years, my lord, for example, maybe.
Then what is the utility of this financial year 2021-22 is written there? Why? What is? That means they wanted to clarify that these would be last 3 years. That's all. And you have not submitted for 21-22.
Young entrepreneur, he has not started his business.
What?
He has not started in the year 2022.
So then you'll have to start a business in 2026. 3 years. Sorry. The bid submitted by the petitioner is rejected at the technical bid stage. Only on the ground that the petitioner has not Yes.
To assist your lordship, I have prepared one and a half page
At
compilation.
the line लिखे दो उसका in that in between. It is no longer res integra that the incorporation of a terms and conditions in the tender document is the freedom of the authorities flowing the set. You are coming up, set aside the office order annexure 1,
The petitioner is challenging the
opposite party number 6 and disqualify
It's
him.
qualified in the technical bid. Though, look, it's a class.
You are also qualified.
Yes, I am also qualified.
So you wanted to weed out the zone of competition.
That's not.
If one goes zone of the competition would be reduced.
But the OP number 6 has not only.
Who is the OP number 6 in the serial number at page 14?
Blood kindly see. You're actually kindly turn to page 50.
I am talking about 14.
But am I, I'm not, are you also holding 879 of 26?
761.
No, I'm so sorry. This matter, this is a big matter. The other one is identical. Kindly you take up this. I'm sorry. 879 of 26. The total non-compliance of tender condition essential terms have not been complied with by OP number 6 still is classified as qualified. Kindly see one. Page 15.
The same document which was looking at page 14. Same document was there.
The same document only page.
Yes. Where is the name of the opposite party number 6?
That serial number 3.
Of
Serial number 8.
Bhadrak or what?
Bhandari Pokhari block.
Bhandari?
Pokhari block. 8 in the first column.
Yes. He is a Biraj Kumar Bhoya.
Biraj Kumar Bhoya.
He is the opposite party number 6. Okay.
Now what
you are?
What is the non-compliance?
Alok. You are Alok. You are serial number 2.
Alok Ranjan Panda.
You are serial number 2.
I am serial number 2.
Okay. And financial bid open?
Financial bid is open.
Birja Prasad is successful.
That not I am yet to know that.
Yet we do know. Biraj Kumar is successful.
Has to be.
Yes. Because no. Your client knows better than you. So if he goes, then others are not your competitor.
Not only that, that's the thing your lordship will not, that is going your lordship's mind, that different matter. But I am on a question. Essential terms have not been complied with by open.
What are the essential terms?
Not that your lordship may kindly take up my note. I have given only 1.5 page to assist your lordship. Quickly I'll take your lordship to this. Lordship may kindly turn to page 30 of my brief. Then your lordship will see.
First thing is that certified statement of the bank account not uploaded.
Now your lordship may kindly turn to
then violation location tracking device.
Second part. Kindly take your lordship may flip over to page 252. What he has filed.
Uncertified copies.
But kindly see. 252.
Yes. Yes.
Well, it is not
downloaded, not non-certified copy. That is what I'm saying.
Right.
It is downloaded from the official website of the bank.
Not certified.
It's true.
Whereas I have submitted a certified one.
Certified. Only thing is one seal is there of the bank.
Seal and signature has to be there.
Correct. Then
authenticity. The second is BLTD, vehicle location tracking device. Plus 4.12 page 32. Your lordship may kindly turn.
Yes.
Page 32 of my brief. But I'll just point out your lordship. There are, but kindly see 32, 4.12.
The
Yes.
meter shall have minimum 2 number of transport vehicles installed with GPS enabled vehicle location tracking device. Registered in his or her name, the heavy vehicle like tipper shall not be considered as a vehicle carrying on food grains for the purpose of this tender.
Correct.
Next, your Lakshmi kindly turn to page 36.
Yes.
But clause 8.1. The bidder shall have minimum 2 number of transport
Same thing.
vehicles installed with GPS enabled vehicle tracking device registered in his or her name. Additional requirement vehicles installed with GPS enabled vehicle location tracking device can be added on hire basis. Next, your Lakshmi see this VLTD is defined. This VLTD is defined at page.
So you have said that though he has submitted the certificate that it is, but it is not an activation slip is not given.
He has submitted the application to give that slip, not even that certificate. He has, would you kindly see that corresponding page is page 127, what he has submitted. Kindly see. Complete violation of essential terms.
Page 100 and?
Page 127.
Huh?
This is only an application for VLTD, not even a certificate. Kindly see. Misleading the tender authority. No, I'm so sorry, I'm so sorry. 265. 260.
Two?
265. Kindly see what he has given along with this paper. 265. But kindly see, this is merely an application. Whereas the certificate should have been asked for 127 pages.
This is what the language is that they inform you that such and such is fitted with VLTD make. These are the numbers, chassis, such and such thing.
Yes.
Yes.
But this is an application, not a VLTD
So
certificate.
where do I find the application? Language is fitted with.
Kindly similar.
Is fitted with.
Vehicle registration number so and so. It is to inform you that he is applying to the registering authority.
Oh, I understand.
Who will certify that? Your Lordship will kindly find from that 21 clause. It is the transport commissioner will certify that it is fitted.
Where?
That your Lordship will find from that clause. That is clause 4.112. Page 32. Open next. 8 point. Page 59. Who will certify that? That is at page 15. Kindly similar W at the top. Who will certify that? As mandated by so and so, any other notification from Odisha from time to time, vehicle location tracking device is to be installed for GPS tagging all vehicles used for transportation of food grains by PDS system. Accordingly, transporters are required to install and maintain with vehicle location device in the vehicles at their own cost. The details of empaneled agency vendors appointed for the purpose are available in the transport department website. So and so must be procured in accordance with the norms established by state transport department and shall be installed in compliance with specification standards available to the above website.
So where it requires a certification by a transport department.
This is
Is only the installation they have to do is what is required is to be done. These are the Vikas agency or something there, the approved agency is given.
I
that
put
name.
example how it is done. Page 127, Lord. Kindly see. This is the kind of certification that is required. Kindly see. 127.
Yes.
Kindly see, my lord. The certificate number is given here at the top.
This is the activation slave.
Yes.
So this is the activation.
That is what is required, Miller.
This is also required. This is also by you to the regional transport officer.
This is what is my application.
That may be certificate number is the device which is installed.
Yes. Then we
Sorry.
No. The third point you may kindly take up. There are 5 points. I have noted it down.
So the second point goes.
Kindly come to the third point. The certificate of registration of vehicles. Kindly see. They just see, my lord, this is page 30, clause 4.1 to 8.3, 8.4, 8.5, page number.
What is the difference between an individual and a proprietorship for?
Fine, that is defined in this.
What is this?
Lord, kindly see clause 8.2.
It is really a proprietor who is the owner, is only doing a business in a compendium, in a compendium name of something. That's all.
In the legal parlance, your lordship's point is correct. But the tender notice specifically defines, kindly turn to page 36, clause 8.3. They say that even if it is in the name of proprietorship, it has to be registered in the name of the real owner. That is the definition.
That is what is the legal recognition.
Kindly see, my lord. Kindly see page clause 8.
I do not know what they mean, but it is a legal recognition. No, sir. No, sir.
In case sole proprietorship, the vehicle must have been registered in the name of the bidder.
What?
That is the kind of peculiarity. In case of sole proprietorship, suppose a vehicle belongs.
I understand,
Right.
sir.
The vehicles must be registered in the name of the bidder. That is what I am relying upon. So if you are giving a particular condition, specific condition in the tender, what he has given is the
Absolutely, I would say.
misconception. But I understand from that angle because the proprietorship.
Sir, the proprietorship concern is also a taxable unit.
Right, bro.
So the individual.
But that's subject to your lordship's consideration. Kindly see then corrigendum clause. Clause 4, page 29. Kindly see. Clause 4, page 29.
What?
But that says that you will have to sign a corrigendum and submit it. He has submitted a corrigendum without signing.
If there is no corrigendum, then
That is there along with the tender notice.
corrigendum is issued only for the purpose of clarification in case there is any discrepancy.
I don't mind your lordship explaining it. Kindly see the.
Why? If I have not committed any mistake, if there is nothing,
There is
it
a
was
mistake.
clarification.
There is an incurable mistake. That corrigendum pertains to merits of the tender. Kindly see, kindly turn to page 29. The kindly see clause 29, page 29, clause 20. 20. Wait, sir.
Sir, accept the defeat, sir.
But I accept. I accept. Point number 1, I succeed.
So,
2 and 3, your
no, I have not opined. On point number 1, I have not said anything.
No, I'll persuade your lordship. Kindly see my other points are there. 1, 2 and 3 your lordships are not accepting. Kindly see the bidder while submitting proposal, submit duly signed copy of corrigendum, addendum along with it. Now what I do submit it. Kindly see Lord page 96. Kindly see page.
Who is for Biroj Kumar?
Lord, I have one more point.
Who is for Biroj
Lord,
Kumar?
I have one
You
more
are.
I am there.
Yes.
I have one more point, my lord. Kindly see. 1 second.
Let a
please.
copy be served, I will see what.
Serve the copy and come back.
I'll come back. but
In
let us
272, I have signed the corrigendum. The proximity is page 272, I have.
Come.
Yes,
No, let them not sign.
Day after tomorrow, as to be mentioned. Take the
First, on complement.
day after tomorrow.
What I pray, my lord, if the
Day after tomorrow.
Lord, if the signed agreement, my writ will become impossible.
You have waited for such a long time. Can't you wait for 2 days?
6-1, they have, Lord, as per their notice, they have opened. Kindly consider.
No, sir.
Lord,
No, sir.
Consider this.
No, sir. You come day after tomorrow. Come.
They have to be
Huh? Then 15th. 15th.
Lord, in that case, can I sincerely pray, man? Let them not at least execute the agreement. But I have.
Let them, we will consider it on that day. If they execute, if they is ineligible, it will go. There is no right which is accrued to it.
Lord,
No equity will come. Don't worry. Illegality.
Lord, I have one more point before you.
15 come. Service. Service. He appears and prays for a service of the copy of the applications. It should be served in course of this day.
In 7
Also serve.
I'll serve copies to them also. Lord, my humble prayer is, since your lordships are not passing interim order, I am just requesting, man. Lord, can it come at the some position in the list?
Top of the list.
That you know. Lord, item 17 also.
Yes.
Okay, item 17. Same.
No, 17 I can't. We have not
Same-
applied our mind.
Same block, Lord,
No.
other one.
No.
16 did.
There are 2 matters that will come. That is one.
Great.
You received the
42.
Lord, in this matter, your lordship will recall, your lordship on 3rd of December had permitted the amendment, and the reply was to be filed within 2 weeks of the amended copy being served upon them. We served the amended copy on 5th of December. Their time would have expired on 19th of December. They filed an IA seeking an additional time on the 13th of December. 23rd of December, sorry. Now they have filed the reply, I believe, on 10th of January.
APF will respond by one. We have filed the reply on 10th of
As per the
January.
original, just 1 second, Mr. Mehta. As per the original order, I get 1 week after the reply is filed. So my filing reply is not till the 17th. So lordship, have it any date after that 17th, I'll file my rejoinder in the meantime.
Yes.
Today's state is also filing his reply.
Reply of counter affidavit, what?
Additional counter affidavit to the amended brief.
Okay.
We have also filed the additional counter affidavit.
I'm serving copy on.
But they should file it well in time, Lord, so that I can respond to all of it. Otherwise, Lord, I'll be unnecessarily struggling.
The other counter affidavit, which was additional affidavit, which was filed by whom?
But the Orissa Mining Corporation respond number one.
Yeah.
They have filed the counter affidavit to the amended date.
That copy has been served on you.
Yes, Lord. Served on me on the 10th.
We had also filed the IA number 23.
The counter, yes.
We had also filed the IA
For what?
2030 for extension of time, but we have now already filed.
So you have already
Actually,
filed beyond the time.
They have already filed it beyond time.
If we accept the counter affidavit, IA shall become infructuous.
Automatically, yes.
Yes. The counter affidavit is filed by
OP number one, Orissa Mining Corporation.
EYOMC Limited or what?
Orissa Mining Corporation, OP number 1.
Okay. The rejoinder
Depending on what date your lordships are giving, if your lordships are having a slightly longer date, then I can take some more time.
yes.
Otherwise, I will abide by that 1 week.
Lakho,
Password for 2 p.m.
Yes.
Item 13, sir.
13. Yes, I'm withdrawing the affidavit which I had filed earlier. I'm filing a fresh affidavit. So,
Milord, I have obtained instruction in this matter now. That agreement is not going to be executed, Milord.
Not going.
Not because, Milord, there is some formalities. Now it is being sent to the government for approval. Once it is approved, then it will be placed before the tender committee. Thereafter, execution of agreements.
It will take some time.
you have to record that in the meantime the writ petition can
Let the additional affidavit filed today be taken on record.
And query bid and successful bidder. The tenure is 5 years. The execution of agreement is year-to-year basis. That your lordship will get at page 14 and Annexure 1. It was for the first year. Executed on 3rd day of May 2021. And so far as tenure is concerned, that your lordship will get at page 16, the last line of the page 16. The lease deed is valid for 1 year.
2nd of May 2022.
And the next page says stone cider which will be valid for 5 years, but agreement is valid for 1 year. This is how the situation stands. But all these sands quarry requires environment clearance and consent to operate. So far as the environment EC is concerned, it stands in the name of the Tahsildar who has floated the tender method. And the consent has to be obtained by the bidder. That what has been granted. Annexure 4 page 50, my lord. It was granted.
Yes.
It was granted on 4th February 2022.
Valid till 31st March 2022, only for 1 month.
Yes. Thereafter, it has not been, and the process has changed. Now it is from Tahsildar. All the sand quarry and stone quarry transport to the domain of the mining office.
Maybe now it is the Pollution Control Board who grants.
Yes, my lord. Now the page 57, the Tahsildar has requested the chairman of the Pollution Control Board to transfer the EC in the name of the successful bidder. Page 57. It was as back as in 18/5/2023. Again, the mining officer, page 58, stated that source remained non-operational from 1/4/2024 to till now. Because of that, consent to operate was not granted, mother.
24 or 22nd?
Sorry, mother, 22nd, 1/4/2020. Just upon the expiry of the consent to operate. Now, next page, page 59, again another letter was issued April 2024. It is by the first one by the Tahsildar, it is by the mining officer who has given the certificate that the quarry is non-operational. This was in April 2024. Here we said that I am to bring your kind notice that the EC of Pulgaon Sand Quarry over such and such hectare at village under 10 Tahsil Jaipur district court has been granted in favor of the Tahsildar Jaipur.
Then anyhow.
The last line, the last paragraph. Hence, I am requested that the EC so granted in respect of the stone quarry may be transferred in favor of the selected leaseholder Sri Gopal Krishna Naik. But that has not been done. I am not operating from April 2022. Now, by Annexure 9 series of demand notices given, almost identical dates, my lord. First two for. And under these circumstances, even I have read page 65 that I have only operated for few days. Even during my excavation, I don't find any stone also. And under these peculiar circumstances, I am prepared to surrender. Because my bank guarantee is lying there, that page 65. Of course, not happily worded, petitioner himself has written, but he has said that I am prepared to surrender. Hence, I pray to surrender my consent order. That consent order doesn't exist as on that day. But he said that I am not able. He said that I could not find trail basis. I have dig 15 to 20 feet.
What is going on in your department?
In this case, his leave has been cancelled, my lord, on 15/3/2025.
For whose fault?
Well, it's if I may hand over the instructions, my lord.
Now I have to come heavily on the department. If these facts are there, I believe it is a time when the natural resources, which is the asset of the nation, cannot be dealt with in this fashion by these officers.
Here the EC was already obtained before EC was already obtained before signing of the lease deed, my lord.
That is what the Honorable Supreme Court
Last Thursday also said, the exact words what your lordship is referring.
Now it is a high time, I tell you very frankly. I have to come up. You will not take any steps to, and very interestingly, that after such a long period of time, the EC is granted for 1 month.
That's CPO. CPO is an obligation of the license.
I am not, can it be granted in this fashion? And how much time you take? Suppose if you grant him for a month, he immediately applies for an extension because the lease period is for 1 year. If he applies, and then you take another 2-3 months to grant an EC for another one month, and then you claim all the dead rent or whatever the royalty for the whole of the period. Who is responsible?
CPO has to be, application has to be made by the listener.
I understand. Consent to operate, he has applied well within time.
Thereafter, after the expiry, whether he has applied or not, there is nothing on record.
Then how can you extend it for that? This is not extended.
Have you ever approached any authority with an application?
No, it's here.
Have you ever?
Where is the rule? When you have given a lease for 1 year or 5 years, then for every month there should be a consent to operate. How can you? How can you give a consent to operate for a month?
Yes, the authority.
I am asking you very, very frankly, how can you give? Why you give a lease for 5 years?
Yes,
Why you have given?
Here is the authority who grants CCO. The application has to be done.
Now it's a high time where these authorities, accountability, the word accountability must be actually prefixed into everything.
Yes.
All their actions must be accountable. It is not that the government is because of them the government is losing a lot of exchequers.
Any authority with an application? How much time?
Very easy to terminate.
Once it was terminated in March 2025, and that is not under challenge.
How can you terminate it?
Because there was dues.
If we are instituting a suo motu writ PIL on this, and we are going against this. We are directing this institution of the suo motu PIL. Whether this role of these officers, accountability aspect has to be gone into or not.
Yet the authorities.
No, definitely.
If a certificate is dependent upon another authority, is it within his control? Or you are saying obligation? Is it within his? Has he not applied?
That is not.
Has he not applied?
That is not. There is nothing on record to show that after the first CTO, whether he has applied for further CTOs or not. His CTO was only valid till 2020.
Environment clearance only there, and that is not there nowhere. Neither in favor of Tahsildar.
Very interesting. Environmental clearance is obtained by the Tahsildar before that amendment came. After the amendment, now entire thing has gone into the mining department. The Tahsildar has also requested that this EC certificate, which I have obtained for this query, must be transferred in the name of a successful lessee because the amendment requires the transfer of those ECs in his name. Even a mining officer is breaking his head to the authority, please transfer it. Unless that EC is transferred, how can he obtain a consent to operate? And everybody is keeping silence. And then suddenly one fine morning you woke up, what? He has not paid the rent. Everything has to be paid by him. Whereas your action has prevented him from operating.
Yes, yeah.
No, sir.
Let's see. I don't represent my CM.
That does not absolve you. Are you divorced from your government? Then is a part of your government department. When you represent the state, you should represent
that organization.
I would say that the government does not have a control over this organization because your submission is that you can't.
Here, as per the terms of the agreement, prior to execution of the lease, ECs were granted in favor of.
Madam, with folded hands, I am trying to impress upon you that it is not the case that the lease agreement was not executed in his favor. It is also not the case that an amendment was subsequently brought in the midst of the tenure of the lease agreement, and EC being one of the very major condition or essential conditions that has to now be obtained by a successful bidder by virtue of amendment. Since the EC was already obtained previously before and under the unamended provision by the Tahsildar himself, he has written that you please transfer EC in favor of him. And the moment the EC is transferred, he is entitled for a consent to operate. How can he apply unless the EC is transferred?
Earlier, he had obtained minors when.
That was a wrong on the part, and that too for 1 month.
Depends.
4-2 to operate till 4-3. Don't execute this query lease for 5 years. Don't give them. Give them for 1 month, renewable or extendable every month. Don't give. That does not prevent you from giving for 5 years or a 1 year. Don't give. Give it for 1 month. It is within your domain. But you can't blow hot and cold at the same time.
Page number 20.
Your fault, and then you are taking advantage of your own wrong.
Page number 20, my lord, as per the terms and the conditions, the environmental clearance shall be valid for the lease period as recommended.
That means lease period is 5 years.
Yes, my lord.
So, is it not valid?
Yes, my lord, it's valid.
Then why you brought an amendment and why this environmental clearance? I will record your submissions. Madam, if you say in this case, I will record your submission that the EC once obtained is valid for the entire period of the lease. There is no question of any further EC to be transferred in his name. And the action of all the authorities are wrong. I will record that and proceed in this case so that it will follow in all the cases. If your stand is this, what is an amendment which you brought in 2021 or 2022?
The authority was transferred.
What are the provisions which you have brought relating to EC? What are the provisions you brought relating to EC?
That's when we checked up one statute was introduced in 2007 on the right of public service. The time schedule is given to many authorities, like value-added tax officers.
Yes.
They were given a time limit for disposing of
all the
for
authorities.
registration. So
Sometimes something
7
like
days.
accountability.
Yes, yes. And it was
Okay,
not that
sir.
statute,
2 years back.
whether tahsildars are given for this purpose or SPCB.
Whether it
For
covers.
that, should I check?
What are the amendments? I think the amendments have been brought where the EC has to be obtained by a successful lessee. That is why the Tahsildar has requested for transfer.
Yes.
Even a mining officer has requested for transfer of the EC in your favor.
That is 2713, my lords. That is with respect to sand query. This matter relates to stone query, which is covered under section rule 33, my lords.
Please look at it. There is then why he has obtained for this shows. Where is a special provision for a stone quarry?
So referring to Rule 2713, my lords, where city mining plan environmental clearance is incorporated in 2023 amendment.
27?
2713. Rule 27 surplus 13, my lords.
Yes, this was the condition. When 29 does not talk about that,
Because 29 does not talk about that. It was previously there, my lords, 29, my lords.
29 does not talk about that.
The city.
It says that it is to be obtained by a competent authority.
Yes, ma'am.
So when the amendment is brought, then how can you?
Because the agreement were executed prior to this amendment, my lords.
So should I take it that this amended provision will not apply to them?
As per
And no, I will, madam, whatever you say, I will record as a stand of the government. Be sure.
because the lease, my lords, only one submission, my lords. Subject to my lords acceptance, my lords. Why I am saying this, my lords? Because as per the lease deed, page 20 talks about the environmental clearance is valid for 5 years, but it's valid for the lease period, my lords. And this amendment was brought about later. And also the clauses, page number 25 talks about CTO specifically, my lords. Project opponent shall obtain CTO from Odisha State Pollution Control Board and effectively implement all conditions. So this was an obligation on that is my primarily was my submission. That was an obligation on part of the leaseholder to obtain the CTO, my lords. Here, after the expiry of that till 22, whether the leaseholder had applied for CTO or not, there's nothing on record to suggest, my lords. And when this was transferred from Tehsildar to mining officer had requested the state CR to transfer the EC because it was originally in the name of the Tehsildar. Now, because the competent authority.
Yes, continue. We will record all those submissions, madam, be sure.
And accordingly,
For future. It's an interesting argument, no difficulty.
whether this was subsequently changed, whether the requirement of EC was mandatory, transfer of EC was a mandatory requirement or not, my lords, that information I don't have to be very frank, my lords.
Then what you are arguing?
This information.
Then what you are arguing?
Because my lords, the
Then is it not there is a dichotomy between the first submission and the second submission?
my lords, what I'm saying is from the lease document, my lords.
There are two aspects. What I gather is that if the lease has been executed prior to the amendment of having brought, then there is no question of any amended provision to apply. Correct? I'm accepting this. I'm accepting this. And we will record the stand of the government. And it will remain within the domain of the Tehsildar, even anything which happens after 2023.
That is the reason.
No, sir, madam, you have to be very sure about it.
Yes, my lords.
If it is a lease which is executed, say in the year 2021, prior to the amendment, or 2020 for a period of 5 years, then 23, if you make an amendment, these amended provision will not apply to you till 2025. We'll accept this. This is a stand of the government and we respect and accept this government.
Here, only, my lords, that is not my submission, my lords.
Then what, then our incompetence to understand your submission?
It is my
Then can you say in a very clear, unambiguous language what is your stand? Because what we comprehend is this. First thing is you said lease was executed prior to the amendment. Take your decision. There is no hurry in this regard. You tell me very precisely your stand. We will record everything what you say, madam. There is no difficulty.
That is what my lord the deal. Where the EC is obtained by the authority, the EC itself puts a condition that it has to be transferred within 6 months. That
Has not been done. Has not been done. Even mining officer after the amendment is writing to a department saying that please transfer the EC. Not done. That is why I am asking her, what is your stand? Tell me.
that transfer has to be done by the state impact assessment.
Absolutely, absolutely. And then the consent to operate depends upon that EC, otherwise not. It cannot be done in absence of EC.
And consent to operate is again given by the state.
Absolutely, that is what I'm saying. It is given. Oh, I've seen that. That's why I'm asking. She's arguing. That's why I'm keeping my patience intact. It is not this case. It will be a future cases that would.
Let's, if I may be given one chance to examine and be thorough with everything else. Because my understanding what was that once CTO was obtained by the petitioner till 22, thereafter it was an obligation of the petitioner to obtain further CTO methods.
Again, please.
Here the CTO
Was obtained, which was operated till 4/3.
31/3/2022.
Two.
It expired on 31/3/2022.
Correct.
Thereafter, he had to apply to the State Pollution Control Board for another CTO mileage. Whether that was applied or not, that there is nothing on record to show that mileage. That was my primary understanding mileage. And regarding EC mileage transfer, that I accept to the fact that even mining officer and tehsildar has stated that it has to be transferred to the petitioner. It has not been done mileage. Only doubt which is there in my mind is that whether the transfer is to be made on my application or on the petitioner application, because there are in various cases I have seen the petitioner applies to the competent authority for transfer also.
When?
Well, it's in some
When?
for transfer.
When the query is after the amendment having come into force. Pre-amendment.
29, 3 and 4.
Yes, I have read. I read it. 29, 3 and 4. And then 27, 13. So,
56. The Lordship may look at Rule 70. Rule 70.
yes. Yes, yes.
No mining operation shall be undertaken by the holder of a mining lease unless he obtains mining plan, forest clearance, environment clearance, and order consent to operate and permission for surface operations. And here it says, the mining lease, the holder of a mining lease. Whereas in 29,
it talks about the authority to obtain.
Yes, before.
So if there is inconsistency in two different sections of the same statute, then which one should prevail or which one will have an edge over the other?
Later.
Yes, madam. Should I record your submissions?
One opportunity may be granted to examine these all aspects, my lord. Here also a focus was issued and hearing was done and thereafter is.
So even a order which is passed after giving an hearing is immune from any interference by the courts, even if it is palpably illegal, palpably wrong.
The facts.
Once the hearing is provided, then every order is immune from the interference or a challenge.
My submission was not that, my lord.
That is what, that the order is passed after giving an hearing. That does not mean that he has no right to challenge. If the order per se is illegal, that he can challenge. That's the right.
Yes, that order is not under challenge because I don't know whether that, because that 15/3/2020
What?
is not annexed in the writ petition, which, and OPDR proceedings has also been initiated against the petition.
Yes.
That is, my lord, I'm just stating the
That
facts.
is more.
Yes, my lord, I understand.
So officer has to be proceeded instead of proceeding agency.
I think it is a high time, after looking into all those facts, that this accountability concept must be brought. Otherwise, these officers, it has a remote, I would say, the indirect or a direct effect or impact on the public exchequer. And if no accountability is attached, it's the public who suffers.
In the morning also you are seeing, once we are opening again, we are revealed. We are not firm on your decisions. We are not.
And in that case, it is one of the alarming, I would say, the example that a bidder has quoted less than 2.6 crores. Yet the authorities, after eliminating him, awarding a contract to a bidder who has quoted more than 2.6 crores. Is it not impacting the government or public exchequer? Awarding a contract at a higher price. Kind of a approach is shown by the authority. They would have called those bidders to match. How can you award at the higher price? No accountability. She wanted to ponder upon the things. Let her say.
PIA and State Pollution Control Board may also be included as parties, my lord, because the delay has been passed on their account. State Pollution Control Board and CR authority is concerned.
We will.
Yes, my lord.
Then we will enlarge the scope of the writ petition. And then we will issue several directions and mandamus on all. We will not hesitate. Then we will say accountability. We are opening then a larger issue.
And then I'll consult 50,000.
Para 7.
Yes, my lord.
Para 7, the transfer from your office to that office. From one office to another office, the records took more than 2 years from the date of amendment.
Yes, my lord.
What is your answer? So one fine morning, you take him to task. By OPDR.
And this is why these persons who are really doing a genuine, they had a genuine intention. They say, I do not want to go into all this. Please surrender it. I wanted to give up. I do not want it. That's why they did not assail the challenge.
And that is.
But you have cancelled, I am happy, I am going merrily. I do not want
October
these.
24.
October 24, it is given.
These genuine persons, they say, I do not want to operate. You just take it back. I can't be put into those, the hazzling provisions.
Government guarantee must have been forfeited.
I think looking at this, you are now trying the way of.
There are unscrupulous person, we know it, but there are certain genuine person as well. You can't put them to such a difficult situations that ultimately they surrender and say that I do not want to continue. Day after tomorrow, take instruction.
15th. Item number 18.
Whereby the government has revoked the letter of intent for grant of mining lease for decorative stone on the ground of delay in submission of the statutory clearances. But without any so-called notice and without considering that the delay is obtaining those statutory clearances is not attributable to the
Same thing. She was harping that whether they have applied or not. Now here the application is pending.
Here it is little bit different. So Lordship will look at page 31.
Yes. What 31?
Page 31.
Yes.
This is a part of that letter of intent. The next page, your Lordship may kindly see page 32. Validity. The letter of intent is valid for a period of 6 months from the date of its issuance.
Yes.
The date of issuance was 27/12/2022. And 6 months expires on 26/6/2023.
Has he applied for all the conditions 3.1 and other?
He had applied for mining plan.
Yes.
That mining plan, he could not submit the bank guarantee, which is a required condition. As he could not submit the bank guarantee, so the process was delayed. And mining plan was obtained only somewhere in 2024, much after the expiry of the period of the letter of intent.
Is it mining plan, the sanction of the mining plan is within his hand?
Yes, is already.
It is within his hand. Once he submitted the mining plan, then the ball really rolls from his domain to another domain. He has no role to play in another domain.
But mining plan he obtained. He obtained mining plan as well as submitted the bank guarantee only in 2024 onward.
After obtaining it,
by that time the period
the bank guarantee is quantified there, or bank guarantee is to be ascertained on the basis of a mining plan.
The basis of
this quantum has to be per annum or something.
Just got the mining plan.
And one letter he has not enclosed. 26 you also will find that page 112.
Mr. Das, kindly appreciate.
Mining plan was submitted since 26/6/24. Now they are cancelling it, saying that you have delayed by as per the contract.
Mining plan was obtained by you when?
26/6/2024.
And on that day you submitted. And how the bank guarantee is to be calculated? This is additional. Is there any stipulation that this bank guarantee of this amount has to be deposited or submitted? Is a performance bank guarantee or what?
But that is a requirement under the mining plan.
Show us the provision.
One letter issued by the Director Mines and Geology that he has not enclosed. Copy of that is 6/2/2020.
I just give a background, thereafter I will come to this point.
Kindly see, like, since 2007, I was granted a prospecting license. The petitioner was granted. The petitioner undertook that prospecting operation. In 2008, I have made this mining plan, application for mining plan. They kept it pending, and in the meantime, the OMMC rules 2004 has been repealed by this 2016. They kept my application pending since 2008. Now, after coming into force of this new rule 2016, in 2022 only, they gave me this letter of intent. Hey, that you have to obtain clearances within 6 months, madam. Now, kindly see Rule 87. Rule 87 says, from 6 months from the grant of precise area, you have to give the license if you obtain the statutory license, or any time thereafter, madam. It doesn't fix any outer time limit, madam. The statute doesn't fix any outer time limit. 6 months or thereafter, as may be allowed by the government. So here, my lord, may consider 2008 is the date of my application for mining plan. They have allowed that. They have not considered.
The old rules are repealed.
That rule.
New rules have come.
Yes. Under the new rules only in 2020.
Now in 2015, the concept of auction was introduced. Then how your application
That is
remained
certified.
proper?
That is a certified clause.
They've done that.
If under the old rule, you have already undertaken the prospecting operation, then those kind of applications are set under this new rule, subject to the condition that you have not violated any conditions in the of this prospecting operation you are undertaking, and you have applied the application. You have made.
What does this prospective operation mean?
That I have to establish that yes, mineral is there in this area by undertaking an operation. That undisputedly I have established since 2008.
So it is you to find out the area where the minerals can be found out.
Chalked out the area.
Yeah.
They have allowed me, giving me a license to undertake the prospecting operation to see whether this area bears any mineral or not. So after undertaking that operation,
Quantum also, I think.
Yes, all these things are given a detailed report I have submitted.
To be extracted.
Yes, madam.
And available beneath the earth crust.
Yes, ma'am. Every detail since 2008 I have submitted along with my application. Under the old rules, I have a fast, those persons who have undertaken mining prospecting operation have a fast right of obtaining the mining lease. Under the new rules, my lord, now it's prospecting lease, mining lease. Now those applications are granted. So if the rules provides doesn't fix any outer time limit, and my lord, undisputedly since a year I have submitted all those environmental clearance, mining plan, everything I have submitted. Now on the ground that while processing your mining plan, you have delayed in submitting the bank guarantee by 2 months. That's their allegation, madam.
Now the bank guarantee, the quantification or the amount has to be ascertained on what basis? The bank guarantee?
But that
Now you must have calculated, or
yes,
you
yes,
must
ma'am.
have calculated.
They have intimated me to deposit.
That letter he has not enclosed.
Page
That is why I
113.
take instruction. from
Page
the
113 is the their letter to me to deposit the bank guarantee.
How much? What is the amount?
2 lakhs. With reference to this directorate memo number so and so on the subject cited above, it is informed you that you have not submitted the bank guarantee for rupees 2 lakhs only as called for therein for approval of the said mining plan. So now they take.
No. So they invited you to submit the bank guarantee within a time. Any time or limit was
2024. You will also kindly see 112 page.
There is
He has referred to that letter, but that letter has not been enclosed.
After delay of 2 months only, I have submitted the bank guarantee.
Why you committed a delay?
That I have also explained in my application that the person concerned who was the applicant, he was abroad, and he was having some health issues which they have explained in detail in his application seeking extension of time. They say that once the letter of intent says that it is within 6 months from the date of the precise area. Now they are calculating the 6 months from the date of giving me the tentative precise area. Now Rule 97 says only when they approve that this is your precise area, from that date the 6 months is to be calculated. Not from the date you tentatively give me a precise area. That Rule 97 is also categorical on that, and there is no outer limit. Kindly see Rule 97
of
OMMC Rules 2016. Rule 98, big pardon. May I please, Your Lordship? On receipt of the application for mining lease, the government shall take decision to grant precise area for the said purpose and communicate such decision to the applicant. And on receipt of communication from the government of the precise area to be granted, the applicant shall submit a duly approved mining plan within a period of 6 months or other period as may be.
That is in relation to a mining plan.
Yes, madam.
Here is in relation to a bank guarantee.
No, bank guarantee for mining plan. They are not, bank guarantee is required by the cooperative who is to approve the mining plan.
So it says that it has to be done within a period of 6 months.
6 months from the date, madam, the precise area is communicated to me. And here in this case, the precise area has been communicated to me in 6/10/2023, madam. So within 6 months, if I have not been able to obtain the mining plan, I have to make an application. The letter of intent says so. That application I have made. Now in the imbued order, they say, from the date letter of intent is issued, 6 months is to be calculated from that date. So you have made the application for extension even after 8 months.
Your case is from the date when precise area is disclosed to you.
Yes.
From that date, 6 months will be gone.
Exactly.
So you are within that
Yes.
6 months.
Yes.
This is the mean that says so.
Yes.
And what is a mineral?
It's a decorative stone.
Decorative stone. Specified minerals.
It is specified minerals.
Specified. And my lord, under rule 14, rule 4, sub-rule 13, my lord, I content that I will rested, right? Kindly see that 4, sub-rule 13. The same, my lord.
Rule 4 or rule 13?
Rule 4, sub-rule 13. May I please, Lord? Notwithstanding anything contained in sub-rule 12, the following applications shall remain eligible for grant of mining lease under these rules. A. Where before commencement of these rules, a prospecting licensee has been granted in respect of any land for any specified minor mineral, the licensee shall have the right to obtain, I laid emphasis on that, shall have the right to obtain the mining lease in respect of that mineral in that area if the state government is satisfied that the licensee, 1, has undertaken the prospecting operation to establish the existence of mineral contents in such land in accordance with the provisions applicable during the period of license. 2, has not committed any breach of the terms and conditions of the license. 3, has not become ineligible for grant of mining lease. 4, has not failed to apply for grant of mining lease within the period of 3 months after expiry of the prospecting license or such further period as may be granted. Kindly see now their letter of intent. Kindly turn to page.
Yes, what do you have to say regarding this?
Repeatedly been fulfilled as per
If it is precise area has already been identified and granted to him, and within that period, if he has, can you put a conditions which is just diametrically opposite to the mining rules?
After completion of the prospecting operation, he made an application for grant of mining lease. Then the government issued the letter of intent. But
that means there should be a precise identification of an area. He may be given a perspective and then say that these are the areas where, according to him, contains that particular specified minor minerals. So the area has to be identified and that has to be granted to him.
But that area, so far as that area is concerned, he subsequently made an application to reduce that area because the entire area he could not operate. He made an application. These are what the
Yes, sir. Precise area once disclosed to him. The dates are very crucial.
Yes.
So the moment, the date on which you have disclosed him the precise area, whatever, reduced area or enhanced area, whatever, according to his mining plan, you have kept silent for more than 9 years.
2022.
The precise area was disclosed to him. Then subsequently he said
that
this much area I cannot operate. That has to be reduced.
Then according to that, the mining plan was supposed to be
So
amended.
when you have disclosed
But
that,
those things I'll produce because only on telephone.
The thing is that-
2008 to
Those
2022,
documents-
you have not said when he was, of course.
Those documents I will bring on record when.
If you delay a process, he will reduce it. He will amend his application.
Let them take an instruction, come in the next week. So come in the next week, speak an instruction.
It's within 6 months. If the time guarantee is within 6 months of.
File your counter within 2 weeks, 1 week rejoinder, 3 weeks.
Nice. Item 19.
That area.
Yes.
Item 19.
This matter relates to extension of the quarry list period. After amendment of the rules, when the records were transferred to the steel and mine department, then manual operation of transit permit was stopped. It was made online. So user ID and password was not provided. So till from 26th of October 2023, mining operation is stopped because user ID and password has not been provided.
It has now been provided.
It has not, till now, it has not been provided, and the period is going to lapse on 18th of January. So under Annexure 8, I have submitted an application for extension of the quarry list period, indicating all those facts. And miners have already held in one of the judgments. Paragraph 8 of the judgment is written.
I will open this.
What? Why you are not?
Paragraph 8, so my representation under Annexure 8, we disposed of keeping in view my miners' observation in para 8 of the judgment. With respect of other sources, they are granting extension. Paragraph 8 is relevant.
Yes. Paragraph 8 is the relief which was granted.
Yes.
It's not a exposition of law.
No.
Let's take a decision and come back on in the next week. Yes.
Item 20.
Or we can dispose of directing the representation to be considered.
It's keeping in view this judgment.
Whatever. You go there, giving you opportunity of personal hearing, convince him by law.
Time is not there, so.
No, they have to. You have come at the last moment.
Yes, 1512 it has been submitted. I could have.
Yes, let's just dispose of this.
When can you appeal?
16th you can appear. Go there. Tell your officer.
16th of because last meeting.
Yes.
Item 20.
Item 20 minus. Here the petitioner is a contractor executing a public work. Under the OMMC rules, there is a provision that for executing public work, quarry permit can be granted. So I have approached the authorities by filing appropriate application for grant of quarry permit. Whenever Canada Annexure 17 at page 36. That my application was forwarded by the department to the mining officer. It's 31st of October 2025. Till date, no decision has been taken on my quarry permit applications. But I am executing a public work, it's a time-bound project.
Let actually one communication is made with the client of the Learned Senior. Probably that is not brought to the notice of my Learned Senior. The department has called for some documents. If they place the document, it will be granted.
What more? Your client is more smarter than you. Has not disclosed this. When you affirmed?
Just filed on 7th January.
Huh?
8th January.
So how do we know?
In the meantime.
In the meantime,
Because this copy is sought to us for 8th January.
Oh, 7th he has filed. Yes,
Yes.
so he was not aware of this document. So how can he?
They might have received it immediately. That's why I told that the instruction is not given.
We're directing you go there and submit the documents. A copy whereof should be given to him.
Yes.
The petitioner is a A-class contractor and obtained the order for construction of a Bali
It is not so. Because there's a matter relating to payment of differential minimum wages that the petitioner has paid during the execution of the work. The brief facts of the case will be large. Some works were awarded by the opposite party number 2, that's the state government, to the Bridge and Corporation.
To the
Bridge and Roof Corporation.
Achha,
which
Bridge
is the
and
government
Roof.
of India undertaking.
No, I know Bridge and Roof.
Lot of works were allotted to Bridge and Roof. We are concerned with item number 25 of the work. Now, Bridge and Roof floated tenders for the same works, out of which item number 25 relating to the work under item number 25 was awarded to me. That stood completed to the satisfaction of the authorities. And they have put it to use. Now, one of the terms and conditions of the agreement signed with Bridge and Roof was that the maintenance of the work had to be done for 5 years after completion of the work. That was also completed. During the execution of the work, there were certain increases in the payment in the minimum wages that were prescribed by the state government under various gazette notifications. I filed several representations for payment of those differential amount. They responded at last to my representation as per Annex 6. The Lordship may kindly come to page 143. They forwarded my representation which
to the ultimate authority.
To the opposite party number 2, that is the state government. Now the state government, Lordship may kindly have a look.
What it says, was there any clause in the parent tender document or a parent contract with the Bridge and Roof?
Yes.
For escalation in the daily wages or something?
I bow down to that. Your Lordship may kindly come to Annex 7, which was the forwarding letter at page 258.
Yes, what it says.
It says to the Chief Engineer, PMGS5, from Bridge and Roof Company. Dear sir, with reference to the above cited subject work, we would like to inform you that Messrs. M.L. Patel has submitted detailed calculation sheet along with court order in connection with judgment Prasad related to wage revision and price escalation and claiming an amount of rupees so and so towards wage revision for the PMG in the Gurundia block of Sundargarh district. As per SBD, that is the standard bidding document, there is no provision for price escalation for the PMGS.
So that is what I wanted to know.
I'll explain that.
There was no provision relating to price escalation.
I'll explain.
Yes.
Milord, it is no more res integra that even if there is no such clause, minimum differential cost in payment of minimum wages, which is statutory under the Act, has to be paid up by the contractor, and it is not a profit that is being made by the contractor. There are judgments of this Honorable Court directly on the point, which has been upheld by the Honorable Supreme Court, and this Honorable Court has also taken recourse to those judgments of the Supreme Court. If your Lordship just permit me, I just place 2 judgments of this Honorable Court directly on.
Now the question is, have they rejected or they have accepted?
No, the state government then reverts back to Bridge and Roof, stating that with reference to the above cited letter on the subject, you are requested to submit the following data, information for scrutiny of the labor escalation bill for the above mentioned work at this end.
True.
1. I'll just go serially.
Yes.
All measurement books containing abstract of all bills may be furnished.
True.
Now, this is not my document. This is never given to the contract.
That is maintained by the Bridge and Roof. They will give.
Absolutely.
So next,
approved final deviation statement and supplementary agreement if drawn may be furnished.
True.
There was no supplementary agreement.
So they will say that it is not to be furnished. If it is not there, not there.
This is what has been written to Bridge and Roof.
True, that is what I'm saying. So they have to comply.
Yes. Now, sanction copy of estimate agreement and sanction order of EOT may be furnished. That is also there.
No, true.
A copy of that is also annexed 2.
True.
Bridge and Roof reverts back to B. While annexed 9, enclosing a copy of the letter received by it from the principal department.
And demanding you to comply.
Now, that is exactly what I am on. Measurement books, it's not within.
That is, they wanted you to comply these
Yes.
requisitions.
Now, one of the clauses they want the order of the honorable court.
Yes.
That has also been given to them. Now, I felt confused by this particular this thing. What am I supposed to do? I met them personally. I met the chief engineer. I met the top officials of the bridge. They are not treating the judgments of this honorable court as a judgment in rem. They are saying we are only paying to those contractors who are equipped with court orders. Now, in this position, Milord, what
So
am I
they
supposed to
wanted
do?
a court order to be brought so that they will comply.
Yes.
So everything should be shouldered upon a court.
Yes.
So let the bridge and roof come.
Yes.
And let us
Absolutely.
notices be issued. Let that come. 2 weeks.
Lordship, it's a returnable date.
2 weeks, yes, sir.
Why don't you represent? Yes, no. Yes.
And also my just humble prayer is that as a senior citizen, he's mostly inside the hospital rather than outside it.
75 is not the age.
No, he's not. He lost his wife, he lost his son, he's not in a mental state, and health issues, grave health issues. 75 is not a very old age, but
Item 22.
the date may be fixed.
It will be. Give it.
Sorry?
2nd February. 2nd February.
Yes.
Item 22.
Here on the last occasion, your lordship has directed the state to obtain instruction for the annexure 6 at page number 32. There is a case where the petitioner was allotted a work which has been completed since 2020, and the annexure 6 page number 32, your lordship may see. This is the official communication.
Final
bill is pending with them. On this letter, they are supposed to obtain instruction for this.
The language is very, very, very clumsy. I could not make a head and tail from this language at annexure 6. What do you mean?
Instructed to file a counter in this matters.
The court may not permit you to file a counter. When a court has directed to take an instruction on the earlier occasion, will you not come forward? Where is it was directed on 22nd of December.
Yes, my lord, sir. In view of that, my lord, we have received an instruction to file a counter. Some time may be granted.
What counter? What is your stand? Tell me.
My lord, why the reason for withholding the certain amount of bill, only 2 lakhs has been withheld. The final amount has been paid, 2 lakhs has to be paid. So the reason behind that has to be stated.
And the work worth rupees how much?
My lord, the work was
What is the total amount which you received from them?
they have disclosed, my lord.
3 crores and odd.
Yes,
Or 34 lakhs.
3 crores some odd.
No, not 3 crores.
Out of which, my lord,
34 lakhs.
no.
Estimated cost of the work is 1 crore 87 lakhs. So you must have quoted what
My
to
lord, in time to permit filing of counter, my lord, the prayer is to dispose of the representation dated 7 July 2025. Seeking for when he has strayed the direction.
Madam, it is not that I am declining. It is that you are not coming with a clean instructions or a clean hand. when a court on the last occasion requested you to just disclose the stand of the authorities, then we expect that at least you should disclose the stand of the authority.
Most of the amount has been discussed. 2 lakh is remaining, and the
Even a 1 rupee, which is a genuine
yes,
amount, can you withhold that amount?
that amount has been withheld because the lower deviation is a pending.
Where,
proposal.
when you have issued, I think last occasion you have showed the completion certificate?
Annexure 6, page number 32.
Yes. No, that is what I say, that I could not figure out, make out a head and tail from this language. What does it mean?
This is the letter which has been issued by the OP number 223 that to submit final contract closure will not.
I do not find this. Final deviation statement in complete shape, whatever may be submitted immediately. Means what? What is the final deviation statement?
For final approval of the what is the liability or what is the outstanding of the present petitioner. That is why the department head has issued this letter to the executive engineer.
Correct.
This is the letter which has been kept pending since 2020.
But what are you doing? 5 years you are not in a position to find out the deviation.
That is still pending approval within the department. So it's
How much time will the department takes to do that? Tell me. How much time will the department? It is issued on 16/9/2020. Now more than 5 years have elapsed. So
That's
You will file counters against this, against your own letter, you will file counter.
No, well, that's just to clarify that position.
no clarification. You have not taken any decision till this time, more than 5.5 years. Whether it is a high time that we should go, that this government, that they have nothing to do on this, direct them to release the payment.
And you see, Annexure 7, he has referred to that letter, paragraph 2, page 33. Come to page 33, second paragraph. As you further know that I have already completed the above work and submitted my contract closure proposal in pursuance to the letter dated so and so, that is Annexure 6 of the office so and so.
I understand that.
Who will bear the compensation?
Till this time, you have not been able to find out any deviation. It will be presumed that there is no deviation. Where is Miss Patnaik?
She has been allotted to a different court now. One week time may be done.
Sorry, we can't. One more time. Who is this authority?
Superintendent engineer, minor irrigation division.
Is it still there? Do you have any information? This who has signed this order is still there in service?
Unless the superintendent engineer will send me the instruction regarding filing the
Same. Who has written this letter?
The designation has been provided. Only the designation has been provided.
No, who has written this letter? Is he still there?
He's your mother, superintending engineer who provided us with the letter of instruction. He's there.
Madam, the query, are you receiving it?
That-
Query which is posed by the bench, are you receiving it?
Yes, no, I understood, my lords. That I'm not aware.
So you say that I am not aware whether he is the same gentleman or not. I know when there is a designation, the designation remains. I am quite aware. But whether the same gentleman is adorning the position or not, or he has been promoted or transferred, that is what my query was. That who has signed this letter, whether he is still there?
I'll confirm. Kindly pass it over. I'll confirm.
No confirmation. Day after tomorrow, we are keeping it, take an instruction and come.
15.
15.
15 to take concrete instructions what they have done. An authority has written to another authority why he has kept silent for more than 5 years.
Item 23.
My humble prayer before me.
Release of the money. Who is standing? Who is this?
Let's hear the document instructions, my lords.
Yes.
7 crores was paid, my lords. 15 lakhs or was not paid to the.
This is what he wanted, 15 lakhs and not could.
Yes, ma'am. Now, it was not paid due to, there was shortage of fund with the department, my lords. The department concerned officer has already requested for that fund to be released to the concerned officer so that it can be transferred to the petitioner.
Since when it is pending?
The 18th RA bill was paid on 9th.
11/7, July 2022.
2022.
I understand the delay, my lords. Last occasion also I had spoken to them so that they could expedite the payment as soon as possible, my lords.
Will be released after
there-
approval. What does this mean?
If,
Will be released after approval of the revised estimate. Petition.
what is happened?
Second couple.
Mr. George?
Yesterday we received the copy from the corporation.
Second couple.
From the,
Corporation, yesterday we received the copy.
Yes,
not by him.
No.
notices were issued.
In fact, she have some copy on the state. State first lift irrigation is there, lordship, so that
State
they have that.
Irrigation Corporation, their order is under
Yes.
them, so they will not.
But we are relying the plus notification of the state sponsor also lordship. There is a relaxation of the city contractors.
The private offices are available.
Yes, lordship, they are particular, so they have select
So you issue a notice, serve them.
lordship.
Serve them.
You have for two, you have for 4, 3, 4, 5. 3, 4, 5.
2, 3, 4, 5.
Mr. Saswada is for 1, 2.
One.
Others with this regulates.
Yes, 2 weeks. Come.
They should proceed to what?
No.
Because
No.
they have already appealed lordship, so that
No, no,
only
no.
they will lordship take care lordship.
No.
Because otherwise it will not.
You are challenging an order or the letter dated 13/10/2025,
Lordship.
which says that it will be conducted on 18/10. I think that has gone.
That is good. We don't mind lordship, but that should not proceed to one.
No.
Because lordship
No,
otherwise.
2 weeks. Let them come.
Item 25.
At least some question lordship to them.
Suppose ultimately if you fail, if they do not execute the work, then who will be responsible for compensation? Then we'll grant a stay subject to you deposit 3 crores of rupees as a security. In the event if you fail, at least that can be compensated. And Supreme Court has said so. I am supported by a Supreme Court judgment. It is not that is a new one.
That's pretty
I will record that judgment or rely on that judgment as well.
If I succeed, sir.
No difficulty. It will be refunded back to you.
It will
No.
Just to show.
If on merit side succeed,
It will be kept in the.
It will be kept here, not to pay to them.
I'm not saying about 3 crores. If I succeed in the island.
It will be refunded that you are agreeing.
Stay lordship.
Cost that will come to you.
If 3 crores, then I can compensate lordship.
No. Because they have to suffer a loss, not you. You are challenging an action of them that they have.
I'm successfully bidden lordship.
Oh, whatever, sir. But, sir, that has to be done. Here we stay the work. That means there will be some kind of a sufferance on their part.
That you say any decision in the meantime, lordship, that will suffice lordship.
No.
Any decision that will lordship that if they will.
No,
if
2
I
weeks.
succeed,
You come
then I-
back.
Yes, ma'am.
Come back.
Item 25.
Please do. In this case, no, the termination of the contract by the putting the 2 units by the National 9, page 98. In this case, the university earlier petitioner had approached this honorable court, where the petitioner's contract was agreement was terminated without any notice by the National 3 university. National 3, page 77. When Lordship has watched the order of termination and directed the opposite party to take fresh steps if any deficiency is there. And subsequently, lordship, they have given a 15 days notice, my lord. After that, National 6, your lordship, page 90. National 6, page 90. Your lordship. They have given a 15 days notice, my lord. And after 15 days notice, your lordship, I did compliance by the National 7, your lordship, page 92. After compliance was given, some of the defect was there. They again asked me for 3 days notice to appear before them and show their compliance.
It's a complete, it's a
lordship,
failure on
90.
his part to comply the.
After your lordship, National 9, page 99.
Medical services, it's.
Oh,
The
that's
CDM.
true. That's true.
So, you are now
Opposite party number 5.
five. We are successful.
Yes,
We
ma'am.
are.
On the last occasion as well, my lord. Here, my lord, as your lordship sees, my lord, may kindly see the show cause.
No. Just.
National 9, page 99, your lordship, see. Here the notice was issued.
Everything was given. You gave a reply.
Just what-
They have noticed. They gave you all the fullest opportunity. Found that you could not improve your performance.
Just what submission? Lordship, page 99, lordship.
Please.
27/10/25.
Yes.
Notice was issued.
Yes.
And your lordship, page 100, my lord, they say that in this context, for above violation of the conditions mentioned in clause number such and such, as you fail to comply with deficiency and unable to improve your performance, despite of several opportunities given to you, your service is hereby terminated.
With effect from 27/11. It has to be 1 month. Sir, this is a health sector. They cannot substitute overnight. So something has to be given that even if they are suffering, something is given to you.
Just one thing I want to draw your attention.
Yes.
You must have the 30 days that was given to me to have a reply or something. After 3 days of left, they have given the work order. Your lordship, page 10.
After so many
And
opportunities, given.
just 3 days after. 30 days is a very relevant period. I will answer them what is the
Correct.
deficiency, how can you improve.
Correct.
But all of us within 3 days of the 30 days notice, 1/11/25. Notice was issued on 27/10/25 and 1/11/25, 3 days after the work order was issued.
But the operative date is
Date it was on 25/12/25. 25/11/25.
No, operative date is that is 26/11.
Right after.
Right, after the expiration of your term. So,
Your Lordship,
it is not that it has really the impinged upon your right.
Your Lordship, Your Lordship knows that the three terms in the 4.8 clause is there. But we have said that the 30 days notice will start after the 15 days notice for compliance. And here in my 15 days notice has been given to me. After 15 days compliance, so we have 3 days notice they have given for personal affairs. After the 30 days period is very relevant.
So they have extended the time that we have terminated it now.
The 30 days
There.
start from 27/11/25.
No.
The 30 days
So up to 27/11.
11, but and that expired on 25/11/25. 27/10/25 and it expired on 25/11/25. Before 27/10/25, immediately thereafter 3 days after 1/11/25 was this work order.
Oh, can be with a prospective effect. What is the difficulty, sir? Only thing is that is their internal problem. That is the internal things. But only thing is the court will see whether it overrides or overreaches upon your rights. If they have said that your right to supply is up to 25/11, even if they have issued the order in the 1st November, but that is made operative from 26th of November, so that your right is not infringed in any way.
The 30 days also the 27/11/25 your Lordship.
It is up to them that this will be.
The date of service and date of termination has to be excluded. As your Lordship knows, various decisions are there that should be excluded.
What?
The date of service, that is 27/11/25, and the date of termination, that is 25/11/25. That your Lordship knows.
That is under the civil law, so far as Section 12 of the Limitation Act is concerned, for the purpose of filing the suit, for the purpose of filing an application, for the purpose of filing an appeal.
But here it is about termination.
How can you bring that Section 12 concept into this?
So,
How can it? Then there are many statute which talks about the computation. Under the Transfer of Property Act, the computation of lease is also provided under Section 110, which is contrary to Section 12 of the Limitation Act. You are talking about exclusion. That is from Section 12 of the Limitation Act. The day from which the period is to be counted shall be excluded.
Yes.
But that is for the purpose of filing a suit, filing an appeal, filing an application.
Here one of the consequences.
But not in this way.
Yes, consequence is termination.
Sorry, 30 days is given.
Before expiry 30 days, they give in the work order. Before 30 days.
Sir, the work order is to take effect after the expiry of the 30 days.
You know, before also they are giving a work.
Can it not? In advance.
You know, in advance they have given in NSR 5 lordships in advance, NSR 5 lordships 6.
In respect of two petition, but in one of the petition, your Lordship passed order at page 61, and it's a 7. In the last occasion, your Lordship passed order directing the state to supply the copy of the reasons of my rejection. Then only I was permitted to amend the petition by incorporating the into law. The Lordship exactly in the similar order is passed under Annex 7 at page 61. Page 61, your Lordship can see. Because I have not satisfied the technical bit, that is the reason. That after filing this writ petition, I will supply these reasons. And that was the previous writ petition was also the same reasons. Your Lordship can return to page 67. I have filed the consolidated here. I am supplying. Already supplied.
Now, what is this writ petition?
This is writ petition, my tender was refused, rejected on the technical page.
This is the 30482 is pending.
Yes, 30482 pending. No counter affidavit is
what?
Exactly same case in respect of another one. between the same parties.
Have you pleaded a party, successful bidder?
That's
So
what.
that, I do not know, till date they have not intimated.
That is what I wanted to know from you.
No, it's, last occasion, prayer was that they will amend the part.
Yes, I have amended. I have supplied the copy. This is my
Instructions
consolidated.
are that the L1 has been selected, but no agreement has been drawn. L1 has been selected in this matter, but no agreement has been drawn because of the similar order has been filed.
So please add them a party, you give the details.
Yes, madam. With only one request, if I may, madam. Here are instructions, my lords. Here at page number 14, clause 4A, my lords. Because this, madam, if I may refer to why the technical bid was rejected, my lords, after the other matter, I had the occasion to call upon the records and examine why was it actually rejected, my lords. Here, my lords, the 4A at page number 14, my lords. If I may refer to page number 14, the two requirement, my lords. One is the works completed and second is work in hand, my lords, which is the clause B. The work in hand is not submitted by the petitioner, and
You may not have work in hand.
that has to be, that has,
Work in hand may not be. Has completed all the works within the time. May not be.
in last matter.
That's why he wanted this work to be awarded to him so that he will do some work. There is a conditions. If the work in hand is already there, which is continuing, he will disclose it. If he does not have the work in hand now, he has completed all the work. From where he will give?
So other matter, he had submitted that he had work in hand, my lords.
True, no difficulty.
Because the
You have a work in hand.
Yes, my lord. In some cases, I have some work in hand. I have
That-
given this. That
Why you
also
have
satisfies me, lord. Annexer 10 kindly have a glance. After I got this, I made a calculation at page 69 kindly have a glance. Annexer 10. Around 17, as per their calculation, 17.59 crores I am eligible to go.
Page,
Page 69 in my consolidated list, my lord. I don't think.
what is the consolidated or non-consolidated?
Man, where will you let me come along with the connected matter so that it can be disposed of. Yeah, I filed on the,
I request all the
I
matters.
filed, I have given the copy.
So we are saying that let's let all these matters be discussed on the after 2 weeks so that we can.
Well, it's 1 week from next week, my lords, because work, this is the work season, my lords. If
Come in the next week. Give the number.
304.
In them, my lord, let me not execute.
Which was one mentioned in the body?
Item,
The fresh matter.
36 was. 36 was. 36.
Item party.
Sorry, I didn't see.
He gets relevant into it.
Yes.
No, we are just mentioning for lots of the matters which is adjourned the same exchange. That's all. Item 48.
This was there in the last day of the petition. The Lordship had requested to today. So tomorrow it may come. I think the review can be done next week. Next week. I had taken a chance on that day, 24th. You're not kindly. Tomorrow, if in that way, I'll be get a business my lord.
Not because small matters which can be disposed of. This review that we have given, I think the. And this matter, the SLP has also been dismissed.
Let us see.
Item 58. Item 50 to challenge the constitutional validity of the particular rules. And Lordship, last time it was directed to list this matter with the same position, Lordship, but it has come up to 58. Only that amendment was filed, it can be disposed of within a week.
35 minutes.
I can't, Lordship.
We are very patient in hearing.
We have already said it will come in the next.
Yes,
Can I take one?
Item number 45 of the petition by the past order. It is a matter covered by your losses, my lord.
What order?
Sure.
Oh, please.
Taken up a hearing on
One per one.
43, item 43, raising.
Just take note of those matters should be given a precedence of the other things.
Only on a specific adjournment, Lordship. Because only we have filed amendment.
Adjourn, yes.
It can be disposed of the minutes, Lordship, because your Lordship already had.
Item 46 is a matter duly covered by your lawsuit judgment.
47.
46, my lord.
46.
Covered by your lawsuit judgment. my
No
lord.
judgment. What judgment?
51 and 58 of Odisha OMNC rules, my lord.
We'll see to it next week.
36 and 47 next.
It will automatically spill over.
41 minutes. I was just saying whether the readings are complete. Maybe
So giving,
February 1st to 2nd.
just remind us.
Your Lordship, item number 34, RC cancellation.
RC cancel.
30.
It can be disposed of the minute, Lordship, so that only a specific.
Item 37 where the item order is.
But item